we have accepted the submission on behalf of the applicant that the transactions subsequent to filing of memorandum on 13/12/2015 are covered by the provisions of MSMED Act. Referring to the provisions of the Act, we have held that if the composition of MSEFC does not satisfy the requirement of the proviso to Section 10(1) of the Act, the MSEFC cannot itself take up arbitration. However, we are in respectful agreement with the opinion of the learned single judge that the same can be a ground for. We are in respectful disagreement with the opinion of the learned single judge that the same can be a ground for quashing of the MSEFC case itself. We are of the view that MSEFC can take up arbitration proceeding under 18(3) of the Act if the composition satisfies the requirement of Section 10(1) of the Act of 1996. If in case it does not satisfy the said requirement, it is incumbent upon the MSEFC to refer the dispute to any institution or center providing alternative dispute resolution services as stipulated under Section 3 of Section 18 of the Act of 1996. This is how we have interfered with the impugned decision of the learned single judge.
I agree.
Item number 2, W1193 of 2022.
Much obliged.
After interpreting the connotation of ditto and referring to certain judgments on interpretation of statute, we have come to hold under the aforesaid factual scenario coupled with the evidence on record, there is no option left for this court than to show indulgence in the impugned judgment. As a consequence thereof, the judgment dated 24th August 2021, rendered by learned single judge in WPC OAC number 1491 of 2014, deserves to be set aside, which this court does. Consequently, we have set aside, and in these circumstances, there shall be no order as to costs.
I agree.
Item number 3, WA3028 of 2023.
We do not find any legal infirmity in the communication dated 3/3/2023 issued by the government of Odisha that Odisha in Forest Environment and Climate Change Department seeking inputs for consideration of promotion of eligible officers to the rank of OFS Group A Senior in accordance with the rules of 2015 by the DPC for the year 2023. The writ petitioners did not fulfill the eligibility criteria as on 1/1/2023 in accordance with the rules of 2015 for consideration of their promotion by the DPC held on 23/2023. Denial of consideration of the cases of the appellants who had completed 5 years of continuous service in the rank of OFS Group A for their promotion in the rank of OFS Group A Senior in the present set of facts amounts to nullifying their promotions to the rank of OFS Group A Junior Branch from the post of forest rangers without following the due procedure. We have referred to Nagaraj's decision also, and in peculiar facts and circumstances, we have issued going to issue directions. Considering peculiar facts and circumstances that the appellants were granted promotion to the rank of OFS A Group A JB from the post of forest rangers by extending the benefit of reservation, admittedly without following the law laid down by Supreme Court in case of M. Nagaraj, though they were appointed as forest rangers, must after the writ petitioners, the state of Odisha shall consider grant of relaxation in eligibility criteria under Rule 14 of OFS Group A Senior, Rules 2015, in respect of the writ petitioners, in consultation with the OPSC for the purpose of DPC of the year 2023, which in the present case was held on 23/2023. Such decision must be taken within 2 months from today. If such relaxation is granted by applying Rule 14 of OFS Group A Senior Rules 2015, the Selection Board / DPC shall hold a meeting within 1 month after the decision on the point of relaxation is taken, as if the meeting was being held on 23/2023, to consider the cases of all eligible officers in accordance with Rules 5 and 7 of OFS Group A Senior Rules 2015 and proceed accordingly in accordance with other provisions under the said rules. In case the state government decides not to grant such relaxation, it shall be required to pass a reasoned order, and in such case, the affected parties shall be at liberty to question the decision of the government not to grant relaxation before appropriate forum, including by way of filing writ petition under Article 226 of the Constitution of India. Further, in the event the relaxation is not granted, the state respondents shall proceed with the recommendation of the DPC held on 23/2023, which is said to have been approved by the government out of the select list so prepared by the DPC, 2 persons have been promoted. The state government shall in such case consider grant of promotion in accordance with the provisions under OFS Group A Senior based on recommendation made by the DPC in accordance with OFS Group A Senior rules. Soon after final outcome of DPC held or deemed to be held shall be deemed to be held on 23/2023, another DPC meeting shall be held, as if the DPC was sitting on 11/3/2024, to consider the cases of such officers who were eligible to be considered on 1/1/2024 in terms of Rule 5. Needless to say that the state government shall take all possible steps to ensure that the promotions are granted to the suitable candidates in accordance with the provisions of the rules as expeditiously as possible by completing the entire exercise, preferably within 3 months from today. We have concluded, we are of the view that the directions noted above balance equities and at the same time do not breach or deviate from any provision under OFS Group A Senior Rules 2015. This appeal is allowed with the aforesaid direction and observations. So will that do, Mr.? It was very difficult task. No.
Item number 4, WA 580 of 2024 and batch of matters.
Subparagraph 8.3 of resolution dated 22/8/2023 to the extent it contemplates preparation of district-wise draft merit list and further stipulates that the district preference will be preferred over merit, is ultra vires Article 14 and 16 of the Constitution of India. The said prescriptions do not have any legal justification. Rather, it defeats the basic object to attract the best talent from amongst the successful candidates. Such provision results in discrimination without any nexus between the requirement of preparation of district-wise merit list on the basis of first preference and the object to be achieved, that is, selection of meritorious candidates for the post of teachers, which is one of the avowed objects of Section 8G of the RTA Act to ensure good quality of elementary education, conforming to the standards and norms. The importance of good quality elementary education has been noted in case of Devesh Sharma. Paragraph 8 of the resolution dated 22/8/2023, to the extent it provides for giving preference to the candidates district-wise over merit, cannot be saved by applying the rule of purposive construction, the language used therein being unambiguous. This court cannot permit clause 8.3 of the resolution dated 22/8/2023 and other follow-up provisions under the resolution to operate, which is patently discriminatory and violative of Articles 14 and 16 of the Constitution of India, though the said provisions have not been challenged by the parties. It will otherwise amount to requiring the appellate state of Odisha to follow a procedure in the matter of public employment, despite the said procedure having been found to be unconstitutional in the light of a constitution bench decision of this court in case of P. Rajendra. After having concluded as above, we are of the considered opinion that the entire selection process undertaken by the appellants for recruitment to the post of junior teacher schematic should not be declared illegal, as that will hinder the completion of process of selection and seriously affect the teaching/education at the school level because of dearth of teachers. We deem it expedient in the interest of justice in the given facts and circumstances of the case to resolve the absurd situation arising out of the stipulation in paragraph 8.3 of the resolution dated 22/8/2023 in a manner that is just, equitable, fulfills the mandate of Articles 14 and 16 of the Constitution of India, and at the same time furthers the objective of Article 21A of the Constitution, read with the provisions of the RTA Act. For the said purpose, we consider it just and proper to issue following directions for the selection process in question. No illegality has been noticed in the conduct of the CBT. Therefore, the marks scored by the aspirants in CBT shall be the basis for determination of the merit of the aspirants. Second, based on the CBT held by OSEPA, the state appellant shall fix first set of minimum cutoff marks, category-wise, subject-wise, taking into account total number of posts advertised, considering the marks secured by respective candidates in the said test. Select lists shall be prepared of such candidates having secured the cutoff marks or above. The preference given by the candidates at the time of application shall be considered for allocation of districts based on merit cum preference. The minimum marks scored by candidates declared successful by OSEPA, subject-wise, category-wise, may be fixed as the first set of minimum cutoff marks. It will be open for the state appellants to refix the set of cutoff marks later from time to time in the event the posts remain unfilled because of non-joining of candidates or other similar reasons, which shall be confined to the number of posts advertised. In view of the admitted fact that score of writ petitioners in the online CBT is less than the minimum marks scored by candidates declared successful by OSEPA, subject-wise, category-wise, we allow the state appellants to appoint such candidates, taking into account their merit based on score in the CBT and direct preference and district preference for the purpose of allocation of a district. It goes without saying that cases of the writ petitioners shall be considered against leftover vacancies in terms of the direction as above. The directions issued by the learned single judge stands modified accordingly. The writ appeals stand disposed of.
Item number 5, WPC 7776 of 2020.
We are of the opinion that serial number 23 of table 2, read with form S of RFP, introduces a classification between such companies who have litigation history and those who do not have. Litigation history cannot itself, the litigation history itself initiated by or against a legal person cannot incur a disqualification from participating in a tender process. Such classification thus does not have any intelligible differentia and nexus with the object to be achieved. Apparently, the purpose of issuance of public notice inviting tender is to select the best from the market. In the present case, by introduction of such clause, the very purpose of fair competition stands defeated. We accordingly declare the pre-qualification condition at serial number 23 of table 2 under clause 2.12D of RSB so and so for selection of successful bidders for design construction unconstitutional, being violative of Article 14 of the Constitution of India. We have framed questions. We have answered questions A, B, and C accordingly. Now coming to the, it has not been disputed that the petitioner has history of litigation arbitration. The petitioner therefore suffered from fundamental disqualification because of pre-qualification condition at serial number 23 of table 2 read with form S of the RFP. This was the reason why the petitioner was challenging the said clause from the very beginning. So we have discussed the circumstance in which the matter had come to this court, and then we have finally concluded in view after declaring the said provision on unconstitutional, we have allowed the writ application with a direction to opposite party number 3 to either issue a corrigendum deleting the said requirement and thus permitting eligible bidders to participate, including the petitioner, for selection of successful bidders, and or issue a fresh RFB without similar pre-qualification condition, which excludes competent players from participating in the process of selection without any valid reason. Considering the facts and circumstances noted above, we are also of the opinion that it would be highly unjust and improper to deny the petitioner an opportunity to participate in the tender process upon issuance of corrigendum or fresh tender notice. We direct accordingly. Before we part with the present judgment, we record our appreciation for the assistance extended by Mr. S.P. Mishra, Mr. Pinaki Mishra, and Senior Counsel for the petitioner, Mr. Ashok Kumar Parijal, and Advocate General for the estate. We especially acknowledge the fair stand taken by Mr. Gautam Mishra, and Senior Advocate, representing the opposite parties number 4 and 5 in this case.
It's a matter relating to promotion of the year 2018. In view of the differences of opinion in the division bench, this honorable court was directed the matter to be placed before Dr. Justice suddenly, my lord. I only pray, my lord, as the matter is of the year 2018 and matter relating to promotion. They're highly prejudiced, my lord, only for the constitution of bench, my lord. Obliged.
Pardon to make a mention in Lordship. Lordship, this matter of division bench constituting Honorable Dr. Justice B.R. Sarangi and Mr. Justice M.S. Raman. Lordship, there's just a typographical modification application I
That will be
filed.
done. You just give your slip to the Deputy Registrar Judicial, that will be done. Give your slip.
Lordship.
The instructions are already there.
Obliged, Lordship.
Test admission item number 1.
You want adjournment in this matter?
My name has not been reflected. I am for an opposite party, Orissa joint.
There is absolutely nothing in this. Who is before the petitioner?
My lord, I am appearing for the petition.
What is there?
My lord, here the petitioner is seeking 15% reservation.
Under which law?
My lord, it's a student of Odisha Adarsh Mahavidyalaya. The notification, one notification has been at annexure 2, my lord, may kindly see. A notification has been published stating that those who have passed out from the secondary board, my lord, they will be getting 15% reservation. My claim is that I am seeking parity. On the last occasion, my lord had heard this matter. My lord had directed to take instruction whether this notification is being another set of notification is coming out for Odisha Adarsh Mahavidyalaya, the students of Odisha Adarsh Mahavidyalaya. That was the case, my lord.
No, otherwise it appears to be unconstitutional, that notification. Yes, have you?
Yes, ma'am. On last directed me to take instruction. Plus, give short time, 2-3 days, so that I can implement.
All right. As requested on behalf of the estate, list this matter on 1 week.
Item number 2.
Your Lordship, item
Next week.
Yes.
1
Obliged, ma'am.
week.
Item 2, sir.
Your Lordship, item 2, may I seek an adjournment for a week, Your Lordship? Because
Why, ma'am?
because Your Lordship, we had sought some instructions from the petitioner, Your Lordship, and he has not been able to give us that instructions. He's an old man of 62 years, Your Lordship.
What is the matter about?
The matter was pertaining the wires of 4A of 4A 7C of the Odisha Education Act, Your Lordship. As-
There are 3 orders. There are
Yes, sir.
concurrent finding of that. How can we interfere in this jurisdiction now? And though all the 3 orders are well considered orders,
Yes, Your Lordship.
what is there? What is there? What instruction? You cannot improve your case beyond
Yes, Your
what
Lordship.
is there in the order.
Yes, sir. That I mark.
We don't find any merit. That 5-2, that one, in that case, this thing, OEA,
Yes, Your Lordship.
you have seen the,
Yes.
the petitioner in the present writ application. Where seems.
Your Lordship,
Don't you have the brief with you?
Your Lordship,
So you're not aware what is the subject
no, Your
matter?
Lordship, I have a certain
Come
what is the
tomorrow.
subject matter.
Come tomorrow, come.
Your Lordship, give me some more time.
There must be some connected matters because
Yes,
this
Your
is of the
Lordship.
year
I
2016.
am only seeking a time because I do not have those number of the connected matters. That is why I'm.
You also find out that the virus have been challenged. It's a year of the year 2016.
I'll try.
So connected
Oh,
matters may
you're
not be
right.
disposed of.
Come tomorrow. Yes.
Lordship may give me some more time to ascertain the
What
connected
for?
matters. We need to-
Ascertain from him, you'll be able to find out.
Your Lordship.
Tomorrow.
Item number 3.
Oh, I thought I don't know.
Yes.
I don't know.
Your Lordships will look at the last order. Your Lordships had expressed an opinion that the matter should actually be referred to Supreme Court. Similar people placed in this matter actually had approached Supreme Court. And this was the direction yesterday. Actually, Supreme Court asked us to approach the High Court
In contempt matter.
in that contempt matter. Last time your Lordships had, in fact, I also went through the order. I somehow agree with your Lordship's opinion, but this order is staring at us. Similarly placed people had been there and because there were additional directions. So
Yes.
Yes. Because I had filed the compliance affidavit saying that we have complied. Now the argument is that we have not complied in true spirit of the order, Milords. As my friend says, now it's pending before the Honorable Supreme Court.
No,
But we
that-
no,
can-
not pending.
The similar people have gone to the Honorable
No,
Supreme Court.
no.
Why don't
I'll
you give
just
him
pass
the-
the
You
order.
have not
Just
given
pass
any
the
copy
order.
to me, just saying
Sorry,
that.
I'll just pass the order. Similar people had been to Supreme Court and the Supreme Court said that you approach the High Court. Though your Lordships, I did compare the High Court order and the Supreme Court order. And somehow I'm one with your Lordships that yes, this matter actually in contempt should have been heard by the Supreme Court.
Yeah, this is the law. This is the law.
Yes, your Lord. There were additional direction. It was not a mere confirming of
So
the order.
doctrine of merger applies.
Yes. And there were additional orders also. There were additional directions also in that order. So, but now we are.
They can approach your Lordships by filing a fresh writ application also. There is no embargo. Yeah, I understand. Now Supreme Court, they said that Supreme Court has stated that you can approach the Honorable High Court.
Whether the Supreme Court's directions have been followed, have been implemented.
Yes, we have stated that in our affidavit dated 6/12/2023, we have stated that in true spirit we have implemented the order by following the guidelines and the directions given by the Honorable Supreme Court. To that, my friend said that said that it has not been followed.
No, your Lordship, they haven't actually followed. Let me explain the matter. What has happened is 2020 actually Supreme Court disposes of the matter, holding the 2001 amendment rules as bad, which was in fact the consistent view also of the tribunal and also of the High Court. But meanwhile, another amendment had come whereby the experience period was reduced from 10 to 6. And your Lordships, the directions of Supreme Court was, you are not going to follow the 2001 amendment and you're going to fill up all the vacancies which arise from 2001 onwards. I get a promotion in 2021. According to me, I should get it 4 years before. So 4 years before, I got it in 2021 as Under Secretary. But as per Supreme Court's order, I should get it in 4 years before. And 4 years before, the 2008 amendment reducing from 10 to 6 has already come into place. So what they have done, they have now relied upon a pre-amended position. Now, 2001 amendment was on a very different point. 2008 amendment was only reduction of experience.
So you are suffering because of the Supreme Court's decision.
No,
Court's decision.
we are suffering because they are applying a particular rule which does not exist in the rule book.
Therefore, the direction was to give you this thing. 2001 regulation was held to be ultra-virus.
Yes.
All right,
Yes, that's a case in my favor.
that is in your favor.
Yes,
And they are giving you this promotion with effect from 2021.
one. Instead of giving it 4 years before. And the reason they are saying is this, that by the time Supreme Court decided the matter, the 2008 amendment had come, and because you did not show it to the Supreme Court, so we will stick to our position prior to 2008.
So this is what we are saying.
Yes,
This is what we are saying, that they are not applying 2008 in your case because of the Supreme Court's decision.
not because Supreme Court has not stated so.
No, they're saying because you did not bring it to the notice of the Supreme Court, we won't give the benefit to you.
Required to be really brought. What the Supreme Court stated is that you fill up all the vacancies. Your Lordship, may I explain what was the 2001 amendment? 2000 amendment 1 was this, that particular cadre had 2 sources of appointment. So they said, unless the person from this source becomes eligible, the second source person cannot get appointment. That rule was held to be ultra vires. So the gates were opened for everybody, and the DPC also was set aside. So then they said, from 2001 onwards, all the vacancies which come, you cannot fall back upon this ultra vires rule. But by the time Supreme Court stated so, it was 2020. And another amendment has only come, reducing the experience period from 10 to 6. So as and when, whosoever chance came, whatever the law or whatever the experience period is, accordingly you're supposed to give. So it's as simple as that. But so therefore, there was no requirement really to bring to the notice of the Supreme Court about the reduction of 10 to 6. That was not the list at all. I don't know why they are doing what they are doing.
No, but whether contempt is measured, deliberate disobedience is,
And they've given me a seniority, even in the case of an undersecretary.
they might have done something which is wrong, which is
Yes.
incorrect, which is legally incorrect.
I
But
do
the
understand.
question is of
Complaint.
Then your
contempt.
Lordship, yes, I'll do. Then my submission will be: we'll get a liberty.
Oh,
We'll agitate this point in the written
Yes,
application.
that is no problem. Yes.
AGA, representing on behalf of the contenders, has submitted that this court's order read with the Supreme Court's decision in dated, where is that?
That's annexure 1. We are
Supreme Court's.
annexure 2. Your
Annexure
Lordship,
2.
you're using your
Annexure
Lordship's
2 and
screen
3.
today.
Yes. The Supreme Court's order dated 1/10/2020 passed in SLP Civil
Yes.
number
6168.
6168 6173 of 2019. Bracketed State of Odisha and Sarda Kant Tripathi and others. Sarda Tripathi and others has been duly implemented. Talk next. Land counsel, from senior counsel appearing on behalf of the petitioner has however submitted that the contemners have denied the petitioner's right to be promoted to the post of undersecretary.
Undersecretary onwards.
Promoted to post of undersecretary. Do you have any date
Yes, on completion of 6 years of my eligibility.
on
They have
completion
given
of
me,
6 years of eligibility
instead
in-
of 10.
in 6 years of eligibility in the light of subsequent amendment made in the year 2008.
2008.
In which regulation? What is the name of the regulation?
Lordships, that's there, your Lordships. Your Lordships will find that. 2008 and 22. That's annexure 7 series.
Odisha Secretariat Service Rules.
Odisha
2000
Secretariat Service Rules 1980.
2001. 2001.
Got you.
We can
No,
say-
not 2001. Yeah, 2001 was an amendment. The main rule is called Odisha
Oh.
Secretary Rules 1980.
1980. So, the senior counsel has however submitted that she may be permitted to withdraw the present contempt application with a liberty to question the decision of the contemners to deny the petitioner benefit of promotion with on completion of 6 years, in which
In
as section officer,
Under Secretary to, yeah, from which post your lordships?
section officer, must be section officer.
No, it's desk,
Section.
no, so it's in fact desk officers, because
Desk
section
officer.
officer, it's desk officer.
Desk officer.
Assistant law officer.
Oh, he's from a different, he's from the
Assistant
law
law
department.
From the
assistant law
feeder
officer.
garden,
Yes.
Different
assistant-
cadre.
That's assistant law officer. Others your lordship may keep it feeder card.
feeder.
So assistant law officer.
This contempt application. Contempt proceeding stands dropped with the liberty as sought for on behalf of the petitioner.
Item number 4.
May I please? This appellant is challenge the order 27 July 2023 passed by the single judge.
Yes.
My lord, the brief fact is that the appellant is filed one consumer complaint case before the district commission. And the district commission is dismissed the complaint. Again, he has gone for the appeal before the state consumer commission. And same is happened that he has confirmed the district commission order. After that, the appellant is come with the writ petition before this honorable High Court. And this honorable High Court is rejected the writ petition.
So what is
My
wrong?
lord, he is
Wrong.
relying on the one case, Ibrahim Faizan versus Omix India Build Home Private Limited in Supreme Court judgment. May I please present the case? Ibrahim Faizan versus Omix Build Home Private Limited.
So that has been followed by the learned single judge.
My lord.
What is wrong in that?
My lord, in this, he is relying on the Ibrahim Faizan and Omix Build Home Private Limited. In this case, one.
Mr. Counsel, that judgment has been relied upon by the learned single judge in your favor. Learned single judge says that a writ petition is maintainable
No, but-
because of that decision.
No, it dismissed, no? Writ petition is maintainability. He is, after that is dismissed. Para 12. The judgment order. Running page 31. In light of the aforesaid discussion having regard to the present position of law, this court
Please
is-
come to court's reasoning and analysis
Court's
part.
reasoning and analysis,
Please.
learned counsel for the
Please
petitioner.
read.
Yes, my lord, this is the learned counsel for the petition is rightfully contended that is held by the Supreme Court in the Ibrahim Faizan and Omix Buildhome Private Limited, that the appellate order of the National Consumer Dispute Commission can be challenged in the High Court in a writ petition. It goes without saying that even while considering the grant of the interim stay or relief in the writ petition under Article 227 of the Constitution of India, the High Court has to bear in mind the limited jurisdiction of the superintendent.
So this is in your, this observation is in your favor.
My lord,
Then
but in para 12, he has written that in light of the aforesaid discussion having regard to the present position of law, this court is of opinion that the writ petition
the
cannot
relief cannot be
any relief.
granted. The writ petition is maintainable, but relief cannot be granted.
My lord. So in this case, he has taken into consideration that this appellant is not gone to this National Consumer Commission and he has passed this order. But Ibrahim Faizan and
My lord, the last sentence is important. That para
let me
11.
finish my. Ibrahim Faizan and the Umesh Build Home jurisdiction that
So which order you had challenged?
challenges order passed by the single judge.
State commission.
State council you challenged the jurisdiction. Hmm?
Yes, my lord.
Order passed by the state commission, you challenge that by filing a writ petition.
Yes, my lord.
So what are we? Are we National Commission?
There is a provision in law
What?
that we can go to the National Commission.
Then?
But thing is that when Ibrahim Faizan versus the Umex India Build Home
So
Limited,
that should be closed then.
my lord.
National Commission should be closed
No, my
because of that decision.
there is a one is there,
Mr. Counsel, we will impose cost in such matters.
my lord.
Because you have resources, you can approach the High Court for anything and everything. This cannot be permitted. So tell us how much.
My lord.
Tell us how much.
Now, another thing, what is the relief you are claiming? 132 rupees ointment you had purchased.
Yes,
You wanted replacement of that.
my lord.
He refused because you did not produce the ointment before the commission.
He's
sir.
telling that ointment is not produced, but is that billed and everything is produced. He's telling that his ointment is not produced.
All right, we are imposing cost.
My lord, I will withdraw my lord. Permitted to withdraw.
Appellant after some argument seeks permission to withdraw this application. This application, the appeal, the Simple Court appeal is accordingly dismissed as withdrawn. This is the fit case for imposition of cost.
My lord, I will withdraw my lord.
Item number 5.
Please, Your Lordship. Now, here this is the second round of litigation, my lord. The appellant is the Odisha Water Supply Sewage Board. Now, the facts of the case are that, my lord, there are 74 DLRs working in the establishment of OWSS.
Let us see where is the order.
My lord, if you know order, Lordship may find at page 40.
Yes.
My lord. May I take Lordship to page 41, the operative portion of the order. My lord, what?
Yes.
My
What did you want?
Lord, here the Honorable Single Judge are directed for regularization of service of the DLR and the ground, and they also directed the state
Who are
of.
you?
Lord, I am the establishment. The respondent, private respondent is working under me as a DLR. I am the Odisha Water Supply and Sewage Board, my lord. If your lordship will come to paragraph 6 of the impugned order, my lord, page 42. May I read, my lord, paragraph 6.
Yes, state. Oh, yeah.
No, private
Legal
response.
notice.
Private.
Yes, sure.
My lord, so my humble submission, we will lordship, lord, that on one hand, this honorable court, my lord, this is a second round litigation because.
Yes, we are. Notices are being issued.
My lord, there is IA, my lord, for stay of operation.
This matter on 8 weeks. Waiting service of notice. In the meanwhile, there shall be history of the operation of the order dated.
Great.
Item number 6.
We have.
Quo motu contempt initiated by your lordships.
Yes. Who is the lawyer?
I don't know, your lordship may issue notice.
What do you say? Where is he? Who is he?
No, sir. Not there, no present. I was trying to find him out.
Just a minute, just a minute.
Mr. Das, Pradeep Kumar
Yeah.
Das.
Just a minute. Which item? Wrong item?
Item 6.
It's just. See, these are the matters which should be resolved in the association.
Right, Lord.
This is not the way. A lawyer should tell the court that you don't hear the matter. And if we don't have any choice, we may have to punish.
Right, Lord.
After 12, please request the President Bar Association to be here.
No.
All right.
I will also request the president.
Is this the practice here in Odisha High Court? A lawyer is telling.
Right, Lord, I will find out.
Item number 7.
Meet teacher also. My lord, in this case, no copy has been given to me, though I am for DMET, who is for nursing council, nursing. No copies has been given to me. During course of the day, sir.
So when?
After 1 week.
Is the matter urgent?
My lord, no, your lordship may give 1 week time to them. No text. 1 week time may be given as paid by my learned senior.
This academic session is 2023-24 is over.
Over, but if your lordship that I have written, if they grant it, it will be renewed for the next year. That
Okay,
is-
just
that
on
is-
paper so that next time. it will
Next year,
apply.
only renewal.
Where is it? Just a minute. Where is your relief? Item
Page-
number 7?
Page 13.
7, 8, 9.
Page 13.
7, 8, 9. Those matters have been decided.
That is different, your lordship. I am aware of it. I have got a copy of it. That is different. Your lordship said that beyond that, nothing can be admitted.
Yes.
That is, my prayer is not that.
Now, what is your prayer?
My prayer is that only inspection is to be done. This honorable court allowed. They have given me a date.
Please
Now,
look
lordship
at
may
your
kindly see
prayer.
the chairman of the institute,
Please come to your prayer.
my lord. That is as per 13, my lord. I am reading the prayer.
Yes.
May I read, my lord?
So everything is over. You are-
That is over, your lordship, but the academic
This is
session
for
to
23, 24, 24, 25.
24, 25, that is by July, August. I have written.
No.
Yes, your lordship, I have written, my lord. That is by July, August, they will take admission.
For
By
24, 25.
24, 25.
Have you applied separately for 24, 25?
No, my lord.
Yes.
Because this matter was pending and your lordship directed,
No.
that I have annexed,
If
my
you
lord.
are not applied, then there is no question.
I have annexed the orders wherein your lordship has directed to consider my case. They have considered,
They cannot.
my lord.
If you want an order, we can pass an order. We will restrain them from entertaining any application beyond the cutoff date.
Yes, your lordship, that is, that order I am aware, my lord.
Then,
I am having a copy of that order,
Then-
which I have gone through.
then,
Therein your lordship has said that if INC has fixed any dates, beyond that, any admission cannot be taken.
no, your application cannot be entertained. You
Entertained.
say you have not applied for 2024, 25.
My lord, my prayer is on a different footing, my lord. If your lordship.
There is no question of footing.
If
The
your
question is
lordship-
of, the question is of that decision.
My lord, if your lordship permits, may I place only one?
No, unnecessary, not, come for the next,
Fees.
My lord,
You want return of your fees?
that is there. I have deposited fees 40,000, 60,000 and the other fees in item, all the three matters.
Council, you could have just made your application for this academic year, which you did not do.
That I
You
have,
failed.
because I have made a prayer that, my lord, may I only submit one thing, my lord? If your lordship will permit, only one submission.
Yes.
My lord, the chairman of the institute, your lordship may kindly see Josnamai Misra. What has happened, your lordship directed them to inspect. Now on the day they have fixed for inspection 5/12/2024, my lord, 5/12/2023. Now the husband of the chairman, he suffered from heart attack, and he was an IIT professor. He was referred from the institute. He underwent bypass surgery.
What order can be given?
My lord, may I pray, my lord? My prayer is that let them inspect the institute. If it is only inspection, if it is
For
found,
what?
if it is found that this
In
institution,
abstract, the inspection in abstract.
no, my lord,
For
not
what
in
purpose?
abeyance.
Huh?
If the institute is found that it has infrastructure and it can run the A&M course,
Sir, they cannot grant you NOC. Where is the question of inspection?
my lord, your lordship, in another case, my lord, I am submitting, your lordship may kindly see, it can be done, your lordship. For 2020, again, for 2024-25, your lordship, it will simply be renewed. Your lordship, in this case also observed that if 2023-24 academic session is over,
So you should made an application for renewal.
I have not been inspected at all.
Sir, your college was not inspected for the academic session 2023-2024.
My lord.
No NOC could be granted.
My lord.
No NOC was granted.
My lord.
Now you could have applied for 2024-25.
My lord.
There is a provision under the regulations or rules that the fee which you had deposited, that will be there. That will be you will not be required to pay further fee.
My lord.
You did not do.
My prayer is that, your lordship, that in this case, your lordship has observed that for 2024-24 academic session, it can be considered. My lord has said.
Yes, we remember.
My lord.
We remember.
My prayer is that, your lordship, when they say that on 5/12/2023 we will inspect your institution, even if the husband of the chairman is suffering from open heart surgery, at the same time, my lord, they have conducted inspection in February and March in other institutions. I have only prayed for 15 days time, that it may be deferred for 15 days from December. But in February and March.
What is the cutoff date?
Cutoff date is already January, it is already over, 24-25.
Your lordship may kindly say Annex 9 I have.
Sir, we are making everything clear in today's order. We will restrain. What is your the body?
Oh, Nursing Council, my lord.
Nursing Council.
Odisha State Nursing Registration Council.
State
Nursing Registration Council.
This order which we are going to pass can be cited in other cases also.
My prayer is that, your lordship, in view of Annex.
Our judgment.
My lord, the earlier one in a group of material also.
Yes. So you will not entertain any application?
Yes, my lord.
Then, your lordship, may I pray, my lord? Your lordship may permit me to apply for the next academic session, and these fees will be counted there, that, your lordship.
We don't know. We will have to examine the rules again.
That,
We
your
don't
lordship,
know. We
may
will just say that this cannot be entertained.
I'll apply, your lordship.
Then you do whatever you want. Then counsel for the petitioner, after some argument, seeks permission to withdraw the state application with the liberty to approach the Orissa State
Nurses Midwives Registration Council.
Sir, Nurses and Midwives
Midwives
Registration
Registration
Council, your lordship.
for grant of NOC.
NOC.
In the next academic session.
And your lordship may kindly, only.
It goes without saying that if any application is met, the same shall be considered in accordance with law.
And your lordship, may I pray, my lord, one small prayer, that the fees I have deposited.
We have also one prayer to make. All right. And that prayer is that please allow us to pass an order. We will make it clear how they will act on your application and how should they act with respect to your whatever is pending.
that your lordship has already, I have gone through this
So
judgment.
we will
Your lordship
restrain.
has made it clear
Yes.
in this case, your lordship, that beyond cut-off then nothing can be done. My lord. My prayer is that your lordship, only the fees I have deposited,
Please you do that.
that they may take into account for the next appendix.
For that, also there is provision in the rule.
My lord.
Yes.
Item 8 and 9.
8, 9, same. In
Item-
respect of other courses.
7, 8, 9, yes.
Item 10.
Item 10, may I please your lordship? Your petitioner has
Who are
challenged.
you, sir? Oh, all right, all right. All right, are you aware of the system which we have?
Yes, they're guiding us.
Do you have?
Yes,
yes.
All right.
This side one, that
Please
side.
try to use that.
Yes, we are busy.
Your lordship, here petitioner has challenged the annexure 1, which is order dated 4/1/2008. In this letter, which was given by the Steel and Mines Department in the year 2000.
You are challenging which order?
Annexure 1, your lordship, that is order dated 4/1/2008, where there was
So
a
why so quick in
Uh,
filing the writ application?
lordship, various representation were given to the Steel and Mines Department in between 2008 to 2022.
So you
Still then-
can be faster, you can file after 16 years,
No, your lordship.
2040.
Your lordship,
Huh?
we have given so many representations. Still then, your lordship, they haven't intimated.
That is
to
what we
different
are asking.
departments.
Why were you giving so many representations for so many years?
No, your lordship, only I'm challenging annexure 1, 2, 3. Because in annexure 1, that is order number 4, dated 4/1/2008, they have passed a notice against the dead person. And the person who died
It is also
on 30. Your lordship, Your lordship, my only grievance is challenging annexure 1 and passing order annexure 2 and 3. Because even though the original applicant, who is the father of the petitioner, who was eligible to get the query lease, still then he was not able to get those lease, and instead opposite party number 4 and opposite number 5, who are the private parties, they were given
What
the
is
query
this
lease.
QL?
Query lease, your lordship, the land which is given for use of mining work, your lordship. Your lordship, here, even though the petitioner in annexure 4, he has provided all the certain death certificates and the documents which is related to the original applicant, who is the father of the petitioner. There, even though he has also provided the no objection, the Department of Steel and Mines, they haven't intimated the letter to other departments who are who have the power to intimate to different departments who can provide them the orders which were on favor of the original applicant, who is the father of the petitioner. Still then, by making various representation letters, even though
Madam, just
reports
a
are
moment.
given.
That order, annexure 2, is it a complete order? Have you given all the pages or just first page and last page? It seems to be incomplete.
Uh,
So that's it. Okay, so that is the extension.
Yes, the Lord.
All right.
My only prayer is, your lordship, to issue notice so that in between,
wait.
because your lordship, I have also mentioned different case laws where it is mentioned that even though we are any notice served to dead person, while further going to any proceeding, we can raise the questions regarding that. I have also.
Please come to, you are challenging, are you sure you are challenging annexure 1?
Yes, your lordship.
Come to annexure 1.
Date chart mentions nothing. It's like a index.
No, madam, sorry. Nothing can.
Your lordship,
The
if one more week given, I'll be providing the other document where your lordship is asking
unnecessary,
about why
unnecessary.
there's
See,
been 16.
because annexure 1, you cannot successfully challenge.
Yes,
If
lordship.
your other reliefs are based on annexure 1, then you don't have any case. So
Your lordship, if 1 week time may be given, I'll provide the documents where your lordship is asking for the why there is 16 years of delay, and I'll be providing other because I have applied in RTA also, your lordship.
on RTI, we don't rely. The present rate application, in the present rate application filed under Article 226 of the Constitution of India, the petitioner has questioned, challenged communication dated 4/1/2008 issued wide number 132 issued by by the Department of Steel and Mines, Government of Odisha, whereby an application for grant of query lease bracketed QL came to be rejected. So stop. The said order reads thus, whereas later. Next. Learned counsel appearing on behalf of the petitioner has submitted that when the order dated 4/1/2008 was passed, he was dead, P. Vengal Rao.
Yes, your lordship.
Huh?
On 31st 5/2005, your lordship.
Then you have the applicant, P. Vengal Rao, was no more and had died in the year 2005
Yes, your lordship.
itself,
31st 1/2005.
31/1/2005. So stop.
In respect of even the expense, but ultimately.
Whether lease was ever granted.
Yes, your lordship was granted, but at the same time, when they got the notice regarding the petitioner, original applicant is no more, they have given the lease to other parties of OP4 and OP5 without the consent of the petitioner who has applied this writ petition before the court, your lordship.
OP5 is son of the
No,
original
OP4
applicant.
and OP5 are private parties. Your lordship.
Just check your cost title. Who's OP4?
No, your lordship, OP4 is different. OP4 and OP5 are private parties. They belong to neighbors only, and they were partners also where they have applied at the same time. But even though
are they private parties or are they partners?
Private parties.
Not partners of the original
They
applicant.
have applied at the same time, your lordship.
There is no case at all. There is no case at all here.
The original applicant has died.
Yes, original applicant has died, even though
The lease was never granted.
No, there is one, that second
This
one.
is only an application.
No lease.
He has applied in 2000.
They're saying lot of persons has applied.
Mile.
Person who ultimately got it, he had not applied.
No, they have also applied.
Your lordship, he was eligible to get, but instead of giving the lease to the original applicant, the father of the petitioner, they have given to OP4 and 5.
Why do you say original applicant?
Because he was the only who applied in the
Where
year
have you
2000.
stated that he is the only applicant?
Grant, my lord.
Grant.
Your lordship, page 4. Clear.
See, you are a young counsel. Had there been some case, some point in your case, we would have.
Your lordship, 1 week. I'll be.
Not for that. Next
Your
case. Next case, we will.
No, your lordship is.
You may remind us when you.
But your lordship, as the last chance also I can provide within a week, your lordship will.
Unnecessary. She has submitted that the impugned communication dated 4/1/2008 is therefore against a dead person and therefore against dead person and thus not sustainable. So stop. The petitioner is legal heir.
Yes, your lordship.
Petitioner is legal heir of the applicant on whose application the said order dated 4/1 in response to whose application the said communication dated 4/1/2008 was made. So, when counsel for the petitioner has argued that there are valid reasons for not approaching this court soon after the communication dated 4/1/2008 was made.
Your lordship.
Oh, stop. Next. We see no illegality in the impugned communication dated 4/1/2008 as noted above. Oh, stop. In any case, the petitioner who is legal heir of P. Vengal Rao, bracketed said to have died on so and so, does not have any right to pursue this matter as the said communication relates to a rejection of an application for grant of QL. This application has no merit, accordingly dismissed. Next time.
But your lordship, obviously all those notice and representations were given to Steel and Mines Department. It was before the Steel and Mines Department. Unless and until those cases has not been decided there, it was not.
Now nothing can be done after 16 years.
Your lordship, but I have provided all the annexures where it is mentioned. We have got reports from the DDM
Not
and
now,
other.
not. Don't waste your chance.
Item 11.
For the other case, otherwise we may withdraw that also.
Your lordship, we request for withdrawal of this matter. So there is a small error in the will file a proper petition for that.
No problem. Small error, then what is the error?
Sir, there have been rule 8 of Odisha has not been complied yet.
The rule you have not complied with.
Yes.
That is the only defect.
No, sir, few other errors as well.
Then you can file an affidavit.
Yes, we'll file a better application for that.
No better application. Let us see what is there in the petition. Which item?
11.
Let us see. We can grant you liberty to withdraw.
Yes, sir.
But we cannot grant you liberty to file a better petition. It is unnecessary.
So, okay, sir, we'll withdraw it.
Well, and counsel for the petitioner after some argument seeks permission to withdraw this writ application. Writ application Stands dismissed as withdrawn. Give your memo.
Yes. Item 12.
This matter, my lord, on the last day, your lordship had asked me to check, my lord. I checked there have been serious irregularities in our part, my lord, and I
See,
I
I'll not make any observation. This is my advice to all the young members of the bar that all of you must go through the High Court rules.
I completely bought
Before
it.
doing
I
anything.
apologize, my lord. I furnish my unconditional apology, my lord. I'll ensure it will never happen again.
We, in fact, speaking for myself, I was disturbed the way the application was filed.
I completely about it.
Color. Learning counsel for the petitioner seeks permission to withdraw this application. First off, this application is dismissed and withdrawn. First off, next we make it clear that we have not gone into the merits of the case. So the points raised in the presented application are left open for adjudication in appropriate proceedings.
Completely bought it.
Item number 13.
In the counter affidavit has not been filed. I see 2 weeks time more.
2 weeks' time is allowed for the estate.
Let's say interim is there.
Why?
Interim order is
The
there.
entry was there
Yes, sir.
earlier.
Yes, that was.
Filing counter affidavit. Notice. No. No. Is there any private response?
No,
No, there is no.
No problem.
No third party rights. And counsel for the, and AGA has accepted notice on behalf of the estate. Also, he takes further 2 weeks' time to file counter affidavit. Also, list this case on 2 weeks. Stop. In the meanwhile, the interim order dated 17/5/2024 shall continue. Application pending,
No, disposed of.
disposed of.
No, no.
Yes.
Records. No, records. Let the records of WPC, what is the case number?
The earlier reads your lordship, WPC 30019 of 2023.
We will record. Or record the listing or.
Item 14.
Obliged.
Right to your lordship. The petitioner, who is the leaseholder of a sand siret, challenging the demand of royalty for a period, my lords, the second year out of the 5-year lease, my lord, where, my lord, that period the petitioner has not been allowed to operate, not the agreement was executed, and that, therefore, my lords, the issue was also not there. After the completion of the first year, my lords, the petitioner has not operated that sand quarry. My lord, suddenly without executing the agreement, the opposite party number 5 has demanded a royalty, my lords. Therefore, my lord, the petitioner has filed an application under Annexure 6 to modify that and to execute an agreement, then allow the petitioner to continue with the lease and lifting of sand, then only royalty can be paid. For a period, the petitioner has not executed the, agreement was not there, and the sand has not been lifted, the royalty amount has been fixed. That is the limited grievance, my lords.
Is it that case where EC was in favor of the government for 5 years? It was transferred in your
Yes,
favor
ma'am.
and ad hoc.
Yes.
And you were supposed to get it extended. What did you
My
do?
lord, EC has been granted in
For 1 year,
for
ad hoc.
then, my lords, from 2024 it has been granted, my lords. But my lords, for the intervening period of 23 to 24, I was not operating, but royalty has been demanded for that period. That is my limited
My lord, that
grievance.
is not correct, my lord. Pursuant to Rule 29, my lord, the environmental clearance was granted in favor of Tahsildar for a period of 5 years before auction. And after auction, my lord, the said environmental clearance was transferred in favor of the petitioner, being the auction bidder. And while transferring the environmental clearance in favor of the petitioner, my lord, the environmental clearance, the CIA, my lord, put a condition, my lord, that the EC will be valid for a 1 year, subject to certain conditions. Lordship, kindly see the environmental clearance, page 16, Annexure 2, for a moment, my lord. Page 16, Annexure 2, my lord. Kindly refer your online application on dated 5/2/2022, where you have requested for transfer of environmental clearance granted by CIA, Odisha, by letter number such and such dated 31/8/2000 issued earlier in favor of Tahsildar Tangi Chaudhar, Cuttack. As submitted by the Tahsildar, it is noted that EC was obtained for Bhatimunda sandbed for a period of 5 years in favor of Tahsildar Tangi Chaudhar, where the above mentioned EC letter under reference. Now the said Soirat source will be leased out under the OMS Rules 2016 by Tahsildar to the successful bidder lessee for a period of 5 years. Hence, the Tahsildar has requested for transfer of EC in favor of Sri Sachin Kumar Sahu, successful bidder under the provisions of OMS Rules 2016 for operationalize of the Soirat source mile. Then, your lordship, kindly see the next page, last parameter. The project proponent has to carry out the engaging appropriate consultant study of the annual replacement rate of sand by collecting pre-monsoon and post-monsoon data from the field to know the quantum of volume of sand deposited, replenished or extracted in the mining lease area. The detailed comparison of both pre-monsoon and post-monsoon elevation data shall be included in the study report. The replacement rate of sand may be calculated by using the volumetric survey method or any other methods as laid down in the enforcement or monitoring guidelines for sand mining 2020 issued by MOEF and CC, Government of India. The finding of this study shall be submitted to CIA to assess the rate of replacement of mined out sand in the lease area. This is important, my lord. Pending carrying out of the study and submission of the report, this clearance is being granted in an ad hoc manner and is liable to be revoked after 1 year, that is after 31st December 2022, if satisfactory replacement study report is not submitted. The submission study report of rate annual replacement of sand within 1 year is obligatory for the project proponent. The PP is allowed to extract provisionally 2000 sand in the first year, my lord. Then lordship, kindly see the next page. Now, lordship, kindly see the page number 19, my lord, Annexure 4, my lord. Because pursuant to this, my lord, within the 31st December 2022, my lord, he has to submit the report, my lord. And in fact, lordship, kindly see the page 19, Annexure 4. This has a reference to an online application of such and such dated 35/2023, wherein you have requested for amendment of regard to annual production sand as requested. Page 19, my lord.
Yes.
The petition has to submit the report, my lord, on or before 31st December 2022. And he did not deposit, my lord. My lord. And on the other hand, my lord, he has submitted an online application on 35/2023. Lordship, kindly see the first paragraph, my lord. Annexure 4, my lord. Page 19 of the CIA, my lord.
Yes.
That's why the demand was, the present demand is issued, my lord. And the present demand is also applicable, my lord, under regular rule 46 of the OMC rules.
Where is that?
Rule 46, my lord. Rule 46 of OMC rules, my lord.
So you could have gone to.
My lords, here, my lords, my case why it is maintained because, my lords, what my learned.
No, we are not saying that your case is not maintainable, but the question is,
my lords,
that if you have the statutory remedy, then why should you not go there?
My lords, I may be permitted, I will file, but before that, might make one submission.
No, if you have that remedy, then you should avail that.
But because yes, my lords, I bowed down, my lords. Only one submission which may be considered, my lords, because I say that is without authority and without jurisdiction because
That you can raise that.
yes, my lord, that
You can
liberty.
raise that, please.
Yes.
Current counsel for the petitioner, after some argument, seeks permission to withdraw this writ application with the liberty to invoke Rule 46
My lord, Rule 46 of OMC rules.
of Orissa Minor Minerals Concession Rules 2016. Against which order?
The demand notice, my lords.
Where is that?
My lords, Annexure 5.
High, my lord, at page 22.
22.
Yes.
Against the later dated 18/3/2024.
Yes.
Brought on record by way of Annexure 5 to the writ application.
For the director.
My lords.
My
Comma before the director.
Director Mines. Minor mineral.
Director Minor Mineral.
Mineral. Odisha. That is a separate directorate.
Stop.
Opposite partner.
We make it clear that we have not gone into the merits of the contentions raised in the present writ application, and the petitioner shall be at liberty to raise all such plea as taken in the present writ application before the appellate forum, if any appeal is filed. Stop. Is it time? Your appeal will be time barred? No.
Yes, my lords. Within 1 month, it has to be.
It is. We also make it clear that if the appeal is filed within 30 days from today with an application seeking condonation of delay, the director shall liberally consider the prayer for condonation of delay and decide the petitioner's appeal on merits.
I'm obliged.
As you come. We will list it tomorrow. Should say sorry. This doesn't look good.
In fact, I was talking to my friend, I had a 5 to 10 minutes of problem with that. He had moved his application for anticipatory bail, milords. Co-accused was already granted bail in some other milords by some other bench, milords. Here, my lord was reluctant to give. He said that in view of the factors, I am not inclined. So he requested it may be placed before some other bench. And subsequently, he has been appearing before that bench, not that he is not appearing.
All right,
So,
that
philosophy,
this has
only
happened,
I pray, resolve it. I will try to.
I can realize you are a fair counsel, and it is not that we are against any. We should be mutually respectful to each other. All right. And this will send a message also that members, young members. And we don't blame you.
No.
Come tomorrow. Tomorrow at 10:30. Oh, bench constitute for 1 minute or all right. Any problem?
Yes.
All right, tomorrow. Discuss tomorrow before a bench consisting of Chief Justice At 10:30. We assure you that we will not make any observation in our order, all right?
But he also not said that
We
he begs
understand,
unconditional
Mr.
apology for his
We
conduct. He is
understand
not,
the way his demeanor, we can understand so
yes,
many things.
he is not shy of, even he is prepared to go to his lordships and I can also take to him before
We'll
the
do it.
lordships. That the lordship may observe also.
We should also at times restrain ourselves that because that order came, I did not have any option.
Right, no, that's true.
All right. Thank you very much.
Item number 15.
May I please, Your Worship? Initially, I have filed an application before the opposite party number 2, my lords, for grant of NOC in GNM course, my lord.
GNM course is over.
Yes, my lord, over. That my application was rejected, my lord. Lordship was granting liberty me to, my lords, the challenging the correctness of the order. But the order, Lordship, may kindly see the order. Page 63, they have passed an order.
The order might be wrong, but
Yes.
what purpose will it serve if we interfere?
Lordship, only for regarding, because they have kept pending, the application is pending for a long time, my lords. They have
Maybe.
didn't disposed of
Maybe.
by intervention of this
Maybe
honorable
nothing
court.
can be done
So,
in view of, unless that judgment of ours is altered
Yes.
by a superior court, we cannot do anything. We are
Lord-
bound by our own judgment.
Lordship, only my prayer before my lords. If a lordship may last two academic session have already last 2 academic session has already been passed. My lord. They have kept pending my application. They have not granted the NOC. Either my application rejected or my lord pass and reason order.
See,
Now-
you will have to rely on that decision because that decision lays down the timeline.
My lords.
Within what time the application is to be filed, within what time a decision has to be taken. So everything is there.
My lord.
They will follow that.
I apprehend, my lord, the same thing will happen. So I pray me for
That will amount to contempt.
lordship.
How can they defy?
No, lordship, the 2 times I have filed a contempt application, then your lordship at dispose of the application, they didn't comply. Thereafter, my lord, I come before my
After
lord.
that order, you have not filed even a single contempt.
Lordship, may kindly one pray, my lords, one thing I pray, my lords. I file a fresh application, they may be disposed of in accordance with law, my lords. Expeditious, that liberty may be granted, lordship. Because the current academic session is 2020 for academic session, 24-25 is concerned.
24-25 is over. Subsequent.
So subsequent.
Also for the petitioner.
A copy may be given to me.
To withdraw.
For the DMT. No copy has been given to me. The order
Because
is
the notice has not been issued, so
Give
that.
him a copy.
So lordship, in course of, I'll give, lord, because the notice has not been a fresh matter, therefore I am not giving it.
All right.
In course of, I'll give.
Your
that.
interest. You can comply, you can take instructions. Why are you not submitting?
Yes.
I want permission to withdraw this application with the liberty to make a fresh application for grant of NOC before the registration council. Nothing. What is the name?
OP?
Well, that's the OP number 2, my lord.
213.
The name of that council, I forgot.
213, my lord. Lordship,
213, Arshi Mahanti.
213. Opposite party 213, lords. The director cum chairman, medical education training.
We are not asking about the learned council. We are saying where you have to make the application.
My lords.
Fully. Odisha Nurses and Midwives Registration Council.
Yes, my lords.
For grant of for subsequent academic session. So Sophie further submits that this court may direct the said council to consider the application if filed expeditiously. Stop. In our considered view, no fresh direction is required to be issued as this court in the case of, what is that?
That batch case where the judge was
WPC
delivered.
39868. 39868.
Has laid down the timeline within which any application for grant of NOC is to be decided. It goes without saying that the opposite parties shall adhere to the directions issued by this court.
Good.
Item 16.
Item 16 are permitted to withdraw.
Withdraw.
Item 17.
No, please.
The petitioner challenges the gradation list prepared, approved select list prepared by the which party for promotion. Wherein the interpretation of the amended rule 2019 manner has been diluted. The earliest rule 1997. I kindly have a glance to the merit. What happened actually, the facts of the case, my lord. As per the resolution 310/2000, the School and Mass Education Department advertised certain vacancies for.
No, you are challenging your seniority.
No, my lord. We are not there in the list, my lord. What happened actually, those teachers who have been appointed as city teachers subsequently acquired higher qualification, and they are now claiming promotion and they have been got promoted. Whereas initially we are appointed as BEd teacher, but BEd, my lord, graduate teacher.
BEd, B-E-D.
BEd. Initially we are appointed as graduate teacher, BA BEd or BSc BEd or become BEd. Those who are appointed as metric city or intermediate city, they have been promoted, but we have not been promoted or
promoted to which rank?
Now we are in level VA, my lord. Level VA.
So give us an example.
Yes, ma'am.
You were not promoted. You have not been promoted, and someone else appointed after you has been given promotion.
Yes, sir. I have, my lord, enclosed a list, my lord, at my lord, page 279. Sorry. 279. These teachers, my lord.
Not moving.
Can you have a glance, my lord? In the gradation list. 279, 280, and 281. I am appearing for the teachers, my lord, for the Cuttack district, my lord. Those who are appointed in the Cuttack district, my lord. And in this, I have struck down some name of the teachers who have been appointed as ISCT, but they are now treated as graduate teacher, my lord.
Oh.
If your lordship will go to the rule.
Just.
This is not moving. This is no. Touch is doing. Oh.
But that should work for both.
It works.
One is working, both should.
Yes.
Yes, ma'am. Annexure 14 series, page 279. I have enclosed the list of some teachers who have been initially appointed as ISCT, But subsequently, my lord, they have suppressed their qualification and got engagement order. Subsequently, my lord, when the rule was amended, they have been implemented, they have been upgraded as graduate teacher, for which we are not been giving promotion. They have been promoted and they are inserted in the
Sir, I have not been able to understand anything.
if my lord,
You were appointed where?
I have been appointed in the year 2003, my lord.
Where?
In the Cuttack district.
As what?
Swechhasevi Shiksha Sahayak.
Exact, say that.
We have been appointed as Swechhasevi Shiksha Sahayak, madam. Swechhasevi Shiksha Sahayak.
Shiksha Sevi means?
Shiksha Sahayak, that was under the
Shiksha
scheme
Sahayak.
of the government.
The name of the nomenclature is Swechhasevi Shiksha Sahayak.
Shiksha Sevi has some English equivalent.
Volunteer.
Volunteer.
What is the meaning of volunteer?
That post is Swechhasevi.
So volunteer, in fact, if you can volunteer for something in the street, you volunteered for teaching. How are you claiming promotion on that ground?
No, there is the provision, madam. I will show you.
So
Maybe.
point that out, how you were made a teacher, so
Yes,
that
ma'am.
you point out. So that
But kindly have a glance to Annexure 2. This is the advertisement against which we have been appointed, madam.
Uh-huh. Where is
Annexure
the
2.
translation?
Madam, thereafter, under Annexure 3 series, engagement orders have been issued, madam.
Now you are showing me an extra 2.
Yes, ma'am. Annexure 2 is the advertisement.
For appointment of Shiksha Sahayak.
Yes, ma'am.
All right.
Thereafter, my lord,
Extra 2 you are saying.
thereafter, my lord, the engagement
Wait,
order.
wait. Honorarium of rupees 15,100.
Yes, ma'am.
Okay.
Yes.
Thereafter, my lord, we have been regularized by at page 63, my lord. We had order dated 26/3/2010, my lord. This is our regularization order. We have treated as regular teacher and posted as level V, A, my lord. At that time, it was level V. I got it, my lord.
Yes.
Thereafter, my lord, at page 74,
Yes.
this is also our regularization order. The number of junior teachers of 13 blocks, CMC.
So when were your services regularized?
Whereas some have been regularized in the year 2010 and some have been 2014, ma'am.
10 and 2014.
Yes, ma'am. Thereafter,
So you entered into cadre in 2010 and 2014.
yes, ma'am.
Then
Thereafter, my lord, at Annexure 5, this is the amendment rule, my lord, 2019. What happened? I will show, my lord.
page.
My lord, page 78.
Yes.
But at page 81, clause 7. At page 81, clause 7.
Yes.
This clause was amended and it continues, my lord, 7A. I am reading, my lord. For subrule 1, the following subrule shall be substituted, namely, 1. In order to eligible for promotion to the post belonging to level B of the service, the candidate must have served for a continuous period of 4 years in the post belonging to level VA of the service. Provided that, next page, ma'am. Provided that 50% of the vacancy shall be filled high school certificate or higher secondary examination or graduation with secondary teachers training, certified teacher, any recognized board or university or equivalent thereof. Eligibility test 1 for candidate engaged as Shiksha Sahayak or junior teacher contractual against the advertisement published after 11/2/2011. Clause 2, my lord. This is applicable, my lord. Clause 2. My case is under clause 2, my lord. 50% of the vacancies shall be filled up by the candidates possessing a bachelor degree in any discipline with secondary teachers training, certified teachers course, diploma in elementary education or bachelor in education or an equivalent examination and training course from recognized board or university and having passed Odisha Teachers Eligibility Test 2 for candidates engaged as Shiksha Sahayak or junior teachers contractual against the advertisement published after 11/2/2011. But this clause is applicable to me. What happened actually, my lord?
Just one moment. Was the advertisement published after 11/2/2011? You have been engaged before that, you are saying. Regularized before that.
I will come to that. That is not my case.
Okay.
My case is that, my lord, in the previous rule, 1997, this is the amended rule, my lord. After amendment came into force, my lord, two categories have been formed.
You entered in level V5 in 2010 or 2014.
Yes, ma'am.
This is correct or not?
2010, yes, ma'am.
2010 and in some cases 2014
Yes,
according to you. This is correct? So how do you make out your case based on this?
Yes, ma'am. I am what actually happened, I am placing your before yours. It is the amended rule, ma'am. In amended rule, what happened actually, they make two categories, category 1 and category 2. Category 1 is the city teachers and category 2 is the graduate teachers. Madam, what they insert, madam, kindly have a glance to.
Are you challenging the rule?
Yes, madam. Yes, ma'am. That's why I am pressing. In para 4.18 in my brief.
Mr. Raiguru, one moment. Look
Yes.
at your prayer number 1.
Yes.
How are you challenging the rule? You are saying that those orders are not legal because they are not in accordance with this rule.
Yes.
Does that mean that you're challenging this rule?
If the entire fact will not be placed before us, it will be.
No, but yes, but when we ask questions.
Entire, you will have to tell us what is your relief before you place entire
Yes.
facts.
Yes, ma'am.
So if you place your entire facts.
No, relevant thing I will place. Madam, kindly have a glance at the
What?
What's this?
earliest rule.
Mr. Counsel, whether you are challenging the rule.
Yes, ma'am.
Where have you challenged?
Prayer number, madam.
Read that first prayer carefully.
The prayer number IV.
What is that?
The rule 11(1)B of the Odisha Elementary Education Method of Recruitment and Condition of Service of Teachers and Officers Amendment Rule 2019 be declared non-nest in the eye of law as violative of Article 14 and 16 and be amended or modified thereby holding Rule 11(1)B of the pre-amended Rule 1997 as just and proper.
So we should uphold that.
Yes, ma'am.
We should set aside this and we should uphold that.
Yes, ma'am.
Uphold, it's very difficult for us to uphold something.
But what is the difference I will
Whatever
show?
is there is always upheld.
But I am showing that what is the difference, what they have inserted, you will also hold rule. I am handing over the old rule, my lord. Though I have quoted in my brief, my lord.
Isn't
It is-
11B part of Rule 11?
Yes, ma'am. My lord.
Isn't Rule 11B part of Rule 11?
Well, kindly have a glance thereafter. Lordship may-
ଦିଅ। କଣ ଦଉଛନ୍ତି ଦିଅନ୍ତୁ।
So this is earlier. This rule is earlier.
Yes.
This is not amended.
It was amended by 2019, my lord.
No,
It
no,
was the earlier rule.
we are asking, this is the unamended rule.
Unamended.
Okay.
My lord, kindly have a glance to 11. Rule 11 of that rule, my lord. Eligibility for promotion. In subclause B, 1B, 1 is there. 1A stipulates that 60% of the vacancies shall be filled up by the candidates having passed high school certificate, higher secondary, that is +2 examination with secondary teachers training, certified teachers course from recognized board or university, and or equivalent thereof. And this, it was earlier, and it was only for matric or +2 60 mark. And B stipulates that 40% of the vacancies shall be filled up by the candidate having passed bachelor degree in arts, science, or commerce, or equivalent with bachelor degree in education. This is my graduate teacher. Graduation with BEd. And in clause 1A, matric or +2 with CT, madam. But in the
Yes, we saw the state. So I have not been able to understand his point. What do you say? What is his point?
He has made contradictory prayers, my lord. If your lordship will look into the prayer number 1, he challenges the select list and prays for a direction to prepare the select list in terms of the amended rule 2019. Then again, he challenges the provisional gradation list, which is yet to be finalized because the final gradation list has not been incorporated. He wants to assert his position within the gradation list, so also in the select list, not implemented anyone who are likely to be disturbed. So that for non-joinder of party, the writ petition also fails, my lord. That is one ground. Then again, he makes a prayer that no, the old rule has to revive and the new rule. So the contradictory prayers, how the writ petition is maintainable, my lord.
yes, madam, this petition is maintainable, madam. I will satisfy lordship that. Madam, kindly have a glance to that. I have quoted that 2019 also, 19 rule.
All right, it will be better if we read the brief. Rather, we should have read the brief. So we
No,
should
no,
have.
they have inserted
We'll hear you
both the-
tomorrow. We'll hear you tomorrow. We cannot make out anything based on your submissions.
And you read your prayers carefully and make your submissions tomorrow.
It is not possible for us.
a day after tomorrow.
No,
Tomorrow, madam.
tomorrow.
Item 18.
May I please, Your Lordship? Your Lordship, in this writ petition, a direction is sought from the opposite parties, especially the opposite party number 3, Your Lordship, to extend the lease for the sand quarry for the period for which the petitioner could not operate the sand quarry, Your Lordship, even if the agreement was executed. Your Lordship, on 5/1/2019, the agreement was executed, The petitioner prepared the mining plan and obtained environmental clearance as well as consent to operate. Thereafter, when the petitioner approached to operate the quarry, Your Lordship, law and order situation was created because the villagers approached. Your Lordship, the petitioner had no fault of his own. Your Lordship, the villagers claimed that it was the land of the temple and the petitioner was a Muslim person, and hence they did not allow him to operate the quarry. Time and again, the petitioner has assailed his grievance to the authorities, Your Lordship, claiming permission after discussing and trying to settle the matter with the villagers. Time and again, the petitioner has approached the authorities to allow him to extract the sand, Your Lordship. However, he was not allowed. And by the time he was allowed, the period ended and he could not operate for a substantial period of time due to the situation that was created. So the petitioner approached the opposite parties to consider and extend for only that period that he could not operate. However, in the meanwhile, Your Lordship, he has paid the government dues and he has installed the machineries and invested a lot of money, Your Lordship. Your Lordship, also the similar matter was dealt by coordinate.
Yes.
A similar matter was dealt by a coordinate bench, and direction was given to consider the grievance. And I have instruction that they had in fact considered and implemented the order, Your Lordship.
My lord, Your Lordship order, my lord, in the JDL chemical matters, not to extend the lease, my lord, beyond the period.
If no fault of the.
No, my lord, lease
holder.
period cannot be extended, my.
I think the other decisions where we have
Because the lease period has already expired since 19/1/2024.
19/1/2024.
5 January 2024. Lease period has already expired, my lord.
Your Lordship, I have instruction that no further auction has been made and it is still not, it has not been granted to some other.
Can be granted, you may participate, but we will have to follow law which has been laid down. Let us see.
This relates to renewal.
My lord,
If I'm not mistaken, this.
renewal after expiry of the period, my lord. To extend that period, my lord.
Here you had applied for renewal of the lease.
My lord.
Was that a point involved in this case? Which paragraph?
Paragraph 25 and 26, my lord.
Or restoration of lost. If I'm not mistaken, paragraph 25, that
25.
so there's a supplementary lease deed had been extended on that.
No, Lord. The lease period of up to 50 years, my lord. And for some time, he could not able to operate. He wants the extension of that time, like this.
The petitioner having accepted the supplementary lease deed
My lord, my lord.
15,
My lord.
in a considered opinion, it would not.
That is
be
in case of renewal, my lord.
So
This
you
is
granted renewal for some period.
up to
Yes.
50 years.
Wanted more, wanted further extension.
Further extension because he could not operate, my lord, due to some.
If I'm not mistaken, I think already you had considered that and granted a supplementary lease deed. He wanted further time.
No, no.
Not that.
No.
So the facts are not very clear from this. No, the Ramesh Sav case.
My lord. Lease period up to 50 years in view of section 10, my lord, maximum 50 years. So he wants the extension for further beyond 50 years.
I'm not talking of this case. I'm talking of that case.
No, that case, my lord.
No, this is different. Come to paragraph 28.
My lord.
This.
My lord. Not in this case, my lord, in view of 80A of the MMDR Act, my lord, the period was up to 50 years. He availed that 50 years. Before that, he has approached your lordship to extend some period which he could not able to operate. Your lordship said, no, this is not possible because the lease was granted for a particular period. Here, lease was granted for a period of 5 years, and that period was over.
No, come to paragraph 28.
My lord. My lord, in this case, my lord, in view of section 8A, the period up to 50 years, my lord. So his lease period was valid up to 50 years.
His P was valid up to 50 years.
My lord.
Thereafter, extension was granted.
He has prayed for the extension, my lord.
Prayed for the extension. Just see.
Yes.
Here we are observing that, as has been noted above, it is not the case of the lessee that there was any disruption or interruption in carrying out the mining activities.
My lord.
After resumption on 5/11/2015 till date,
My lord.
the lessee knew that by virtue of section 8A of the MMDR Act, the validity period of lease was being extended up to 20/2/2024 upon completion of 50 years from the date of original lease.
My lord.
That is this 21/2/1974.
My lord, because 5/11/2015, my lord, one supplementary agreement was executed for further period up to 50 years.
Up to 50 years.
50 years.
The doctrine of acquiescence was there.
Right.
He agreed to the supplementary lease deed for that particular period.
Right.
Here he has come up for the first time.
First time, my lord, that period is 5 years. That period is over.
That is the original period.
My lord, there is no extension, my lord, in the minor mineral. There is no renewal.
But in cases we have seen, this court has directed where the failure to operate is on not account of any fault of the lessee. In some
Well,
cases, it probably
File
is
an
granted.
affidavit.
My lord, I'll file.
8 weeks. Because let's this matter on as requested on behalf of your so and so accepts notice on behalf of the opposite parties. To stop as requested. List this matter on 8 weeks so as to enable the state council to seek instructions and file
Right.
affidavit. 8 weeks on 8.
Published.
Lordship, and a copy may be served, Judge. A copy may be served, Your Lordship.
Copy.
Copy of the
Sir,
You will serve.
No, Your Lordship.
Then
A copy may be, Your
a
Lordship.
counter naturally.
Yes,
counter
yes,
they
Your
will
Lordship.
survey.
Item 19. my lord.
Pledge, Lordship.
Your Lordship. All Odisha additional computer programmers. All Odisha additional computer programs association is before Your Lordship. They have challenged the rule under Annexure 4, my lord. That the rule is the Odisha accountant cum data entry operator, method of recruitment and condition of service of Rule 2024, specifically Rule 4, where no reservation is made for them for additional computer program for their appointment, regular appointment. my lord.
Reservation. Is
For
there any
their regular appointment. You will also kindly come to Annexure 1. 2 posts were created by the government. One is that
Mr. Your submission is that there should have been some reservation.
reservation, my
For
lord,
whom?
for this additional computer programmers.
Additional continue.
They are the contractual employee.
So is there any reservation?
Reservation has
constitutionally
been given,
mandated?
reservation has been given 30% reservation.
Listening to the question, Mr. Mahanti.
Yes, I am giving answer. my
So
lord.
whether this reservation is reservation under the constitution or reservation under some other provision of law?
My lord, the reservation has been provided to Gram Rojogar Sevak, 30% reservation under that rule. My lord, both the Gram Rojogar Sevak and these additional computer programmers were appointed under one notification, my lord. These Gram Rojogar Sevaks were appointed in the Gram Panchayats having plus to qualification with computer qualification at all level, my lord. These additional computer programmers, they are addition to that computer programmers, my lord. This is the additional computer programmers. They are engaged in the blocks, my lord, having graduate qualification with O level qualification in computer, my lord. Then the post 7,142 posts of accountant and DO, data entry operators, were created by the government of Odisha on 2/1/2022. They are engaged in 2006, my lord. The new posts are created on accountant data entry operators in 2022, my lord, under Annexure 3, my lord. Then rule was framed by the government for recruitment of this accountant data entry operator under Annexure 4, that is the accountant data entry operator method of recruitment and conditions of service rules 2024, my lord. Rule 4 provides that 70% of posts shall be filled up by direct recruitment.
Where is that?
Rule 4, my lord, at page 23, your lordship.
Page 23.
Page 23, my lord. Rule 4, methods of recruitment. Not less than 70% of cadre strength shall be filled up by direct recruitment through the commission, and not more than 30% of cadre strength shall be filled up by means of the.
So why are you using this expression reservation?
My lord, we are the.
Where is the reservation in that?
That only 30%.
30% is reservation.
That is not that the post shall be.
Reservation is a technical expression.
Reservation is, my lord, that is regarding that your lordship, meaning to the caste.
So where is this reservation?
My lord, my lord, they have been
Rule 4.
30% has been for 30% posts are reserved for the Gram Rojogar Sevaks.
Then you have not read the provision. If this is your understanding of this provision, Rule 4, that there is reservation, 30% reservation.
That has been, my lord, provided, that percentage is provided, my lord. If I will not use the language reservation, the word reservation, my lord, otherwise I may say that the 30% posts are meant for the Gram Rojogar Sevaks.
Read it.
Yes, my lord.
Read it. Either your English is poor or we are not able to understand.
My lord, I am reading again, my lord. Methods of recruitment.
Yes.
Not less than 7% of cadre strength shall be filled up by way of direct recruitment.
Yes.
Through the commission.
Yes.
Then clause 2, sub-rule 2, not more than 30% of the cadre strength shall be filled up by means of selection of eligible GRS, Gram Rojogar Sevaks.
Yes. This is, what is this? This is
they will be selected among the Gram.
This you are reading this not more than, you are reading not less than.
Not more than, not less than. Only
not less than.
Maximum it can
be. Not more than means not less than.
Not less than. It can be.
What is this?
Not less than means up to.
Up to 30%.
Yes.
Up to 30%.
So how are you saying that 30% posts have been reserved? Why are you using this expression?
Well, it is meant for that. Not I am not using that word.
Forget reservation. Forget reservation. You are reading this not more than as not less than.
Not
this is your
less than has not been, not more than 30%. It may be 30%. It may be less than 30%.
It may be 1%. It may be 2%.
Yes, it may be, my lord.
But it cannot cross 30%.
Well, but not less than 70%, my lord.
No.
So you can come in 70%.
I am 70. That is for direct recruitment.
No.
So you can apply.
That is for direct recruitment.
That is not less than.
That is not less
Yes,
than.
so that can go to up till.
That is my lord. That is
also.
for the direct recruitment candidates, my lord. Direct recruitment for here, my lord. As Gram Rojogar Sevaks were engaged, my lord. They have given the 30% already. My lord.
Mr. Please try to understand this simple thing.
Yes, my lord.
That Rule 4 does not provide that 30% of the cadre strength shall be filled up from selection through eligible GRS.
GRS.
This is not the minimum. It says up to.
Up to, my lord.
So therefore, even it can be 1%,
Yes.
2%, 0%. So therefore, your submission that at least 30% of the posts are, this is what you had started your submission with that only.
Maximum 30%, my lord.
From 30%.
30%.
So where is the question?
That
of-
can be,
So there is no reserve, there is no post fixed for them. They
They
can.
have already implemented that under Annexure 6 for
And it does not
Ramraj.
violate any provision.
Yes. My lord, here, my humble
In fact,
submission.
it is a bar. More than 30% they cannot take. So if there
More
are too
than
many applicants,
30%
they
I am
cannot
not
take.
submitting, my lord. I am
So
not.
why are you saying reservation? This is in fact a
Not
bar.
I am submitting 30%.
Reservation is there
My
in
lord,
Rule 5.
we are appointed along with this, the multipurpose Gram Rojar Sevaks. We are also appointed on same notification having higher qualification. My
Whether advertisement has come.
no advertisement has not.
So
yet
we do not find any illegality in this.
My lord, your lordship kindly come to that we have to be regularized, my lord. We have sought for. If they provide that, my lord, some posts up to 30% for the Gram Rojar Sevaks, my lord.
It does not provide for. It lays down a bar. It is against them. The provision is against them.
That has been already been implemented under Annexure 6, my lord.
Let us see. Annexure 6.
Your lordship kindly see Annexure 6, my lord.
No, was any separate weightage given to them? Well, there's nothing in the rules to give them any
Rules
preferential treatment.
that up to 30% may be for
Again, up to
eligible.
30%, that is a bar. If they are otherwise qualified, they will be appointed. You will also be appointed if you are otherwise qualified.
Otherwise qualified, my lord, as a direct recruiter, my
Yes.
lord. We can't appear as direct recruiter. They are structural limitations.
You can compete against 80%, 90%.
We can't compete, my lord, because we have been appointed since 2006, my lord. Now it is 2024. We are age barred if direct recruitment is made, my lord. And all the computer programs, my lord, you will also hear me for a moment. All the computer programmers have already been regularized under Annexure 7.
Or do you mean to say these GRSs were above the age limit?
Yes, my lord. All are above the age limit. Well, they cannot make an entry to the government service at all.
No, not come. We're talking about this.
Then, my lord, all the data entry operators appointed on contractual basis, they have already been regularized. My lord. We have been left out, my lord.
That can be your grievance.
Yes.
But how can you challenge the rule?
Rule, my lord, only in this context I have challenged, my lord. If you provided some post for...
Please try to understand that you started your submission with a wrong premise altogether.
I used that, my lord, that which is, my lord...
Reservation is reservation, forget reservation.
That is not
you are reading Rule 4 in a different way altogether.
That is not appropriate wording, my lord. I consider that may not be an appropriate wording of reservation, my lord.
No, forget reservation. You are reading no more, no less. What is this?
My lord, they have given that 30% post up to the Gram Rojar.
All right, we will decide it.
Government also misread that
My
provision.
lord, I say one thing.
No, my lord. Your lordship has seen that Annexure 1. If your lordship will see that Annexure 1, in Annexure GRS, that is Gram Rojar Sevak, your lordship has page 15. Their appointment and this claiming they are appointed through outsourcing basis, as it appears from page 16.
There's also.
Yes, my lord. Your lordship may see. May I read, my lord? Engagement of additional computer program in order to handle huge additional energy data and online monitoring reporting. Each panchayat samiti can deploy one additional computer program will be engaged preferably on outsourcing basis.
Preferably.
On outsourcing basis.
Preferably.
Yes. And your lordship has seen their read petition, and that read petition, not a single appointment order has been attached to this read petition.
We are initially appointed to subsequent to that. We have been appointed through contractual basis.
He is relying this. And
they are under Monrega, my lord. They are under Monrega. Both the posts are under Monrega, my lord.
And so far as multi-purpose assistant is concerned, your lordship may see page 15. They are how they are to be engaged.
We have higher qualification. We have not been given regularization. On the other hand, Gram Rojar having less qualification, they have been given the post of this accountant come data entry operator.
You stated how you were appointed on what basis? Contractual basis or outsourcing?
Well,
Have you stated that?
contractual basis.
Where have you stated?
Stated my letter. Paragraph.
Where are the appointment letters?
I am giving this.
You have stated in paragraph 3.
Well,
contractual basis.
paragraph 3, my lord, paragraph 3. That the petitioner is the association of additional computer programs who have been appointed on contractual basis in 314 blocks, not in the Gram Panchayat.
Then
What
paragraph
my
5,
learned friend submitted in each Gram Panchayat.
Without engaging.
In each Gram Panchayat, Gram Rojagar Sevaks are appointed.
Where is your appointment letter?
We have not given the appointment letters, my lord.
You have not been given appointment letter.
Mr. Mahanti, one moment. Go to
I'll
paragraph
give-
5. Paragraph 5 last sentence.
Yes. That in the said order, government decide to appoint additional computer programs to handle huge additional energy data and online monitoring practice in Panchayat Samiti. The minimum qualification for the said post is graduate having computer proficiency.
You are reading your petition.
Yes, my lord.
You don't have any appointment letter.
Appointment letter I have not, through association we have come, my lord, therefore we have.
Association
given
you cannot
individual-
maintain. Association is registered.
My lord, it is affiliated to that all Orissa. I'm giving that it has been affiliated to. My lord,
You
all
are
Orissa.
doing, you have already done a disservice to your client. They cannot be called even a person because they are not registered.
No, they are affiliated to Odisha State Non-Gazetted Officers Coordination Committee, my lord. They are affiliated, my lord. That which is a registered body.
Is your association registered? No.
No, that we have affiliated to the organization which is a registered body.
What is that?
Item 20.
Well, one thing I pray, my lord, I have prayed.
You
that-
can give your written notes.
Item,
I'll give a written note, my lord.
item 20.
In your written notes, you will have to mention
Yes.
the manner in which you were engaged. All right. Otherwise, apart from dismissing the writ petition, we may initiate proceeding against your clients. So you will have to mention in your written notes of argument.
Item 20, my lord. Can you be taken up next week? I will serve copy on my learned senior, which I have not served my copy.
What is this about? This is nursing.
Nursing.
Over.
Renewal nursing, my lord. My lord, kindly sit for a moment.
Nursing is over, sir.
Listen for a moment, my lord. Page 11. I have applied NOC for issuance of NOC on 29/1/2023.
For which academic session?
For 23-24, my lord.
So that is over.
I am not claiming 23-24.
Yes.
Thereafter, they have issued NOC. My lord, kindly see it is just little different, my lord.
Yes.
Kindly see page 27, they have issued NOC
Yes.
under Annexure 1 on 16 January 2024, my lord.
26,
Page 27, my lord.
page 27. Yes, they have issued an NOC. Yes.
NOC. But thereafter, I got affiliation by Annexure 4, page 29.
Yes.
There, when I applied for renewal of NOC for the session 2020-24, they have said that since online application should have been submitted on or before 20th January, my lord. But after that, I got the affiliation on 16/2/2024, page 31, my lord. My submission is that
You applied for renewal for 23-24, 24-25.
24-25.
Say that.
I have applied renewal for the session 24-25, but they have not issued.
So what are they saying?
They have said that since the online application is to be submitted by 20th January 2024, for that reason, they have not accepted my
So
offline.
why did you not submit your application?
I will give my.
How can you do that now?
And Mr. Mahanti, what is the use of these NOCs if you give it after the date
My lord, last year,
Fair.
no, my lord, that's why.
This case also did not apply on 16 MSC. But still they have to apply. No, in every case that had happened. No, that case which I cited, that case also I don't see they granted. So what can be done now?
Due to lapses of.
Lapses you can
Though I have applied in time,
You
by
can-
due interference by.
You did not. In fact, this NOC was granted on 16/1/2024.
For the session 23 to 24.
What was the last date? For 24-25, what was the
25, my lord, kindly see page 33, I have and 20th January 2024. My lord, thereafter for renewal NOC, one I have to be affiliated. Thereafter, they have kindly see the page 31, my lord. They have approved my institution on 16/2/2024, my lord.
No.
Page 31.
22-1.
16th February, my lord.
So that was for 2023-24.
My lord. Since
So you knew on 16/1/2024 that is useless. And you had to apply for renewal
renewal, my lord.
by 20th of January. You did not do that.
After obtaining this, my lord, on 16/2/2024.
16 to forget, why are you not reading this 16? Whether on 16/1/2024 you knew that you will have to apply for fresh NOC for the next academic session.
For application for renewal NOC, my lord.
You did not do that.
I do, my lord. But they have said there since.
When did you do? And that is our judgment.
Yes, my lord.
Kindly taken up day after tomorrow.
All right, day after tomorrow as requested.
I will obtain that.
And see that decision. We cannot deviate from what has been laid down in that case.
And did I make pardon, my lord, previous item, submission of within 3 days?
Whenever. It's very difficult.
Your Lordship, item 21 may kindly be called up tomorrow. Your Lordship, my learned senior Mr. Palit is inconveniently please.
Question. I'll be question.
Your Lordship, item 22, similar prayer. Yes, Your Lordship.
Yes.
Obliged.
1 week after, on behalf of Mr. Barik. On behalf of Mr. Barik, please tell you 1 week.
On behalf of?
I'm from petitioner.
Just look
On
at
behalf
your
of Mr. Barik.
cause title. Had you approached this court earlier, there's no certificate? Supposed to give a certificate that you not approached this court earlier. Is there any such certificate? Are you understanding what I'm saying? When you file a writ application, you have to give a certificate in the cause title. Usually it's given in the cause title that you were not before this court, or if you are before this court, the details.
Your grievance is that some public land has been illegally encroached. All right.
Actually, my seniority.
No, we can see.
Prakash Ranjan Bari.
We can see that. Oh, government land. Oh, we are disposing that off.
So 1 week of time.
No, not required.
Item number 24.
May I please,
That is the best order you could get.
may I please, your lordship. Here, my lord, the petitioner institution applied for no objection certificate, no objects.
No.
Petitioner institution applied for NOC for the academic session 23-24 for the in respect of BSc nursing course, my lord. That is Annexure 1.
So that is over.
Along with the application, he had deposited all the statutory required, my lord. Then after almost 1 year, they rejected our case. Then I approached this honorable court, Annexure 2. That order impugned was set aside. That order was set aside at Annexure 2, page 18, where this honorable court had to consider my case afresh. That is the order dated 29th January 2024, my lord. Then, my lord, by the Annexure 3, page 20, they granted NOC for the academic session 23-24 on 14th March 2024. By that time, already the academic session was over. As well as I was desisted from getting renewal of for the academic session 24-25 because by that time the online was closed. Because they have
When the case was disposed of by this court,
that online very much active.
what was the last date?
Last date, my lord, lordship, Annexure 5.
What is the last date?
Last date was, my lord, 8th February 2024.
Yes. 8th February 2024 for what?
For online application for renewal of NOC 24-25. But I could not apply it because they have granted in month of March. So now he has been registered. The institution
Month
has
of March, they have granted you NOC.
no granted NOC as per direction of the Honorable High Court for the academic session 23-24. By that time, the sessions was over. I could not
That was
take
your prayer.
admission of the student as well as I could not renewal of for 24-25.
When you came to this court, you were not aware of the last date. That must have been
That
published
was
by
not,
them.
my lord, that notification not there. Lordship may see the Annexure 2. It was disposed of on 29th January 2024.
So if we allow your writ application, then what?
Only
will happen?
my prayer, my lord. So NOC they have granted. That may be converted 24-25. Whatever the statutory fees
There
have
must be law. We cannot make law.
because all formalities required for inspection, etc. They have completed. They found the institution has become suitable. So now
Nothing
because
can be done for this academic session.
Mr. Das, look
24,
at Annexure 4, page 22. What is the last date for application?
page 22, my lord. This is the application invited.
This is the last date.
The last date they have not reflected, my lord.
Last date of receipt of application is 30th November 2023.
Then, my lord, next annexure.
Yes.
The last date of online application for renewal of NOC for existing institutions under the Council of Nursing Pharmacy so and so, it has been extended from 16th January 2024 to 20th January. Then again, Annexure 6.
Existing.
Annexure 6. Again, it was extended, my lord. The application for new NOC and recognition starting from new institutions and renewal NOC change of so and so, it is closed. So by 8th February, the online applications for the academic year 24-25 was closed. By that time, they are not granted NOC. NOC was granted in the month of March, my lord.
No, therefore, see, your earlier application was rejected. That rejection order was set aside. The court directed them to reconsider. They reconsidered and they granted you NOC.
But 23-24, by that time, sessions were over.
Sessions were over. So suppose 8 years after, in 2030, the court decides something about 2023-24 session, then what
my lord, only my
purpose will that serve?
But my predicament, the institution found suitable. we have invested as for their norms and norms, my lord. So there is a laches on part of the DMAT. Lordship may see after 1 year they rejected the case. They could have done it. Lordship may say for a moment their notifications. I have annexed 7.
Council, they might have done something extremely wrong. But whether the relief which you are saying
Relief
can
is
be
the only
granted.
your lordship has under Article 226 has.
No, we cannot violate law.
I have gone through your lordship judgment.
Yes.
But still the laches lordship.
Laches may be there.
So only for renewal for the next sessions. Whatever the fees required, it can be, my lord.
It can be done. It can be. We are just trying to streamline the
Yes, lordship.
this situation. That was the purpose why we had to write that judgment.
So because of their laches, my lord, the institution as well as the students who are
Their laches,
interested to take admission.
At least after that.
Latches on both sides. You have also come late. You've not taken any date for
Late.
disposal of your.
Well, after rejection, I came immediately. 29th of the order. They could have given on within February. My lord, one thing may pray, my lord. I will approach the authority. If they'll consider because they found the institution has become eligible.
direct that. We can direct. Just see the nature of order which we are passing. The learned counsel for the petitioner submits that learned counsel for the petitioner seeks permission to withdraw this writ application with a liberty to approach
OP number 2, my lord, DMAT.
Director of Medical
Education and Training. Director of Medical Education and Training.
He is the authority or he is the authority?
He is the authority, but the Odisha Nurses and Midwife Registration Council is to consider and the DMAT has to approve it.
So he has to approve then.
Yes.
To whom will he approach? Both or?
He will apply to DMAT. It will be considered by one MRC.
Oh.
It will be applied to through.
DMAT for grant of NOC for BSc nursing course for subsequent academic sessions in accordance with this application is disposed of as having as withdrawn with a liberty to the petitioner to approach opposite party number 2 so if he approaches opposite party number 2 in accordance with the procedure prescribed, the same shall be considered. The petitioner's request for grant of NOC shall be considered in accordance with law, particularly taking into account the observations made by this court in case of GKF loss. GKF.
Matters are there, Your Lordship. But one relating to OEA proceeding, the other relating to Orissa Servant Settlement Act proceeding. But this is a case where actually
No, but if possibly some party has died.
Expired, actually, notice was supposed to go. My friend was there before the closing of the, your lordship will hear the matter, then question of notice will be there. Notice is may be required because they are their interest is going to be affected, in fact.
No, but if your case is dismissed, then
Yes, nothing is there. If my case is dismissed,
that background we might have.
absolutely, your lordship is correct. I can't have an issue on that. But here the question is, but I would like to raise a question of jurisdictional point.
In the first case.
In the first case. Jurisdiction in the sense, so the OEA Act actually after it came into force.
Okay, let me see, section 5(2).
5(1).
5(1).
So, dead check. Can you have a look at section 5(1), Marat?
But how 5(2) is mentioned in the order?
It says 5(1), in fact.
That is an error.
Right.
In the order. Have you noticed that?
Section 5(I). It is 5(I).
5(I).
After the notification was made, the property of the bahildar, that is the intermediary, vests in the state. After vesting takes place, this procedure has to be followed. Section 5(I), small I.
Yes.
It says where the collector, got it?
Yes.
Where the collector is satisfied in respect of settlement or lease of any land or mines or minerals comprised in such estate, or the transfer of any kind of interest in any building used primarily as office or kacheri for the collection of rent of such estate, or as rest houses for estate servants on duty, or as golas for storing rent in kind or part thereof, made or created. This is a very important word. Made or created at any time after first day of January 1946. That such settlement, lease, or transfer was made with object of defeating any provisions of this act or obtaining higher compensation thereunder, he shall have power to make inquiries in respect of such settlement, lease, or transfer, and may, after giving reasonable notice to the parties concerned, to appear and be heard, set aside any such settlement, lease, or transfer, dispossess the person claiming under it, and take possession of such property in the manner provided in clause H, on such terms as may appear to him to be fair and equitable, provided that in case where the collector decides not to set aside any such settlement, lease, or transfer, he shall refer the case to the Board of Revenue for confirmation of the settlement, lease, or transfer, and the order passed by the Board of Revenue in this behalf shall be final. Then other things are not be required. Here actually, if you also kindly see the word collector. Collector has been defined. If you also looks at 2 small s, section 2, 2D, ABCD. Collector includes an officer appointed by the state government to discharge all or any of the functions of the collector under this act. But this is a case, what has happened, the villagers filed objection before the ADM. ADM referred the matter to the Tahsildar. Tahsildar so moto initiated a case as if he discharges his function as the collector.
He is not the collector.
No, sir. He is not the designated collector as per the notification. I'll show that. He referred the matter to the revenue supervisor. The revenue supervisor inquired the matter. He gave a report. He referred to a document where section 3(1) notification was made. Section 3(1) notification says about my vendor, that is my bahildar, that is the intermediary. But he has given a report, the person who has given me lease is not a bahildar. That report is there. On the basis of the report, Tahsildar functioning as the OA collector, inquired into the matter. And he gave a report that 515I proceeding is valid and justified and refer the matter to the sub-collector. Sub-collector Sadar, who is also not the designated person as collector, inquired, sat over the matter, passed the order, which is the subject matter of dispute now.
So who is the collector?
So if your lordship looks at the notification issued at the relevant time, 1963, designating those persons who are acting as the collector, is I have filed, that is annexure in the rejoinder affidavit, annexure 18. Annexure 18, page 124. The rejoinder starts at page 45. The document is at 124. The persons who have been designated by the state government, it says number 11635 11-8/63R in pursuance of clause 2D. 2D is the collector definition of the Orissa State Abolition Act. The state government do hereby appoint the following officers to discharge the function of a collector under clause I of section 5 of the said act in respect to the area specified against each without prejudice to any of the power of the collector of the respective districts or any other officer appointed as collector under this act to discharge the said function.
In your case, who is the collector?
Sir, collector, here the collector's, the sub-collector name doesn't find place.
All right. He is not a collector.
Right.
The order, the person who passed the order, he also may not be collector. You are right in your submission. But according to you, as per this notification.
They have not notified anybody.
No,
in respect of the area, concerned over which the land situates, nobody has been given the assignment to function as.
Which area, which district is
that? Is Vidyadharpur in Cuttack. That is a remote area of Cuttack part.
Cuttack Subdivisional Officer Adhagad.
Yes, that is not the area, sir. And he is not the person. Subdivisional Officer Adhagad is not the person who exercises the power.
That we have.
The previous one, Mr. Mishra, the same page, there is another notification.
No, there is no other notification.
Additional Tahsildars.
Additional
that is
Tahsildar.
J and K, all right.
Oh, that's different.
Yes, yes.
They have to function under the other provisions, 6 and 7.
But this you have produced from the manual. There is no other document.
There is a notification published in the but government is to produce. If they produce some document.
All right.
We will ask.
Neither the Tahsildar nor the sub-collector Sadar has been designated to function.
That submission
Yes,
we have understood. In fact, we are thinking that if at all we interfere with the order on this ground, then
they have to remand it back.
Who can do that? Therefore, we are trying.
Government has to notify somebody to examine it.
So government may.
It has to be re-examined again.
Oh, yes, you're right. This is a very fundamental question. Who is appearing for the estate?
State, I can appear now, sir.
Mm-hmm.
But I think it's a matter where so many private parties are there. I don't know whether anybody is representing them or not. The lordship is opposite parties 7 onward or 2 minutes.
So we find substance.
23. There are so many opposite parties.
No, opposite. There are two aspects.
Yes.
If we are satisfied that the person who passed the order was the collector within section 5I of the act, then, and we are further satisfied that there being concurrent finding of fact, we are not required to interfere. Then no notice is required. But if we are satisfied that the person who passed the order was not the collector within the meaning of the
Yeah,
act,
within that meaning of the act, then it's a nullity, Your Lordship may say.
so do you have any, they must have filed.
They have held a counter, no reply has been given on that.
Which paragraph have you raised that point? You were saying in your
I have
joint
raised it,
act.
my lord.
Where?
Read application, if Lordship looks at it. Paragraph 17, I think. Read application, I've raised it.
And did you raise it in your appeal? No.
Yes, sir.
There.
If Lordship looks at,
Paragraph 10.
my lord, paragraph 11 also I have indicated. Paragraph 10.
But
At
how
page-
is it that the collectors for other subdivisions?
Yes, they have notified it. They have notified. Artgard's, he has got a jurisdiction in respect to the areas which has been earmarked for them. But for this area, nobody has been.
What about paragraph 11 of your writ petition?
Yeah, paragraph, sir, may I kindly have a look at
No, no,
paragraph 8, last portion, my lord.
No, paragraph 11, you said since it is the lease of the year 1942, no collector had been appointed.
Yes.
Paragraph 8. Appellate authority, revisional authority have not considered the facts.
No, these are not. They have actually gone on the premises that there was no vendor, the intermediate is not in existence. Therefore, all the leases are void and antedated and all those
No,
things.
no, that was, they didn't have the jurisdiction to initiate this proceeding. Has that point been raised?
No, jurisdiction point I'm raising before your lordship, my lord.
Mr. Samantra, have you examined that?
In
The
fact,
main point is jurisdiction.
only jurisdiction. The file was allotted to Mr. Mati. He had to go to that bench, so Kotak PL bench at 2 o'clock.
Okay.
So that's why he requested me to just
He requested, but you're not saying.
proxy counsel.
No, just see the conduct of your client.
Well, your lordship is absolutely correct. The person who initially filed the writ application, he died. But the lawyer didn't take any steps with due respect. I'm not blaming anybody.
That could
I'm
have
blaming
been
myself.
restored.
For the filed restoration application that was not allowed, then he expired during pendency of the restoration application. Then settlement operation concluded. Then that was challenged and the writ application was filed. I have to mention everything in the court also. I have disclosed everything.
Which paragraph?
8.
No, that this happened.
I mentioned about the previous writ application. In the,
Paragraph 8, yes. Father.
and interestingly, the person in whose name the property was there, she has not been noticed. That is Gunjan Dei. She has expired in the meantime. She has never been noticed by the sub-collector.
So you will file substitution or what?
So then the legal heirs came forward, in fact.
You will have to file.
I didn't understand. What did you say?
Sir,
Who expired and who has never been substituted?
substitution was filed during pendency of the earlier writ application. Not here.
Notices are not issued in this case.
Yes, notice has been issued.
So whether there is any service, in the service report,
Sir,
something is mentioned?
Yes,
that-
notice has been issued here. And it has been mentioned that against one of them, the notice has not been made sufficient. So I thought your lordship may direct for the fresh steps, my lord. So that is what the matter was listed.
Who are the legal heirs of Gunjandi? One of them?
Yes, they are the parties, madam.
Because you have stated some are pro forma opposite parties.
Yes. ये क्या है क्वेश्चन जी? हाँ. They are the daughters of the son of the Gujandi.
Okay.
So whether as on date collector
But
has
your
been
lordship-
notified or not?
But your lordship will dispense with the notice in respect of the legal heirs. Madam. If I succeed in this writ application, I succeed. If I fail, I fail. They stand the same footing. There is no contrary adverse interest. Therefore, your lordship may hear the matter. If your lordship feel that yes, there is a legal point to interfere, your lordship will interfere.
If you interfere, the interest won't be affected.
They will not be affected in the sense if I succeed, they
Yes.
get the benefit also.
Oh, you can take this stand that they are not required to be substituted.
When at your risk.
At your risk. That is all. Call.
We can file a memo. We can file a memo if you wish. But let them verify that point. My friend is there. He can.
Please verify. This
Yes,
is very peculiar.
And
There
subsequent-
are two aspects.
Yeah.
See, even if subdivisional officer of this area
Yeah.
was notified as the collector in the meaning of the act, the order in this case has been passed by Tahsildar.
Yeah.
He is not even subdivisional officer.
no.
So if that order has been passed in exercise of that power 5-1, in the order he has mentioned 5-2.
That's
Have
wrong,
you
madam.
Huh?
There
Have you
is no
seen that?
5-2.
5-2,
Yes. mistake.
5-2, 5-I. So in fact, I was there. Therefore, in the morning, I was trying to search.
Yes, yes.
And I thought that's
Right, sir. man, Right, sir.
wrong in the book. But so Tahsildar is in any case, Tahsildar is not a collector,
Yes,
cannot
he
be
can,
collector.
that's so he cannot pass the order, even if he has passed, it has to go beyond. That is one
And he
question.
refers matter to sub-collector who signs the order. He also not designated.
And I also, the subsequent question will also be whether any notification has been made,
Presently, who's the?
who is the.
When was the first order passed?
Sir,
First order, when was the first order passed?
first order is, if your lordship looks at the additional affidavit,
No, annexure 1.
Annexure 1?
sir, annexure 1 is by the sub-collector.
Acha, 28/11/70.
Yes,
Report of
Tahsildar's
Tahsildar.
order is annexure 20, my lordship. You can see annexure 8 also, but not readable, therefore annexure 8. Annexure 8, lordship, you can see. Sorry, 20. Page 133.
Annexure 8 and 20 are the same.
Same. That is only typing, this is handwriting. I have given the type
Oh,
copy.
acha. That is subsequent affidavit.
Page 133, annexure 20 is the typing part, my lord.
Acha.
Legible copy. That was obtained by right to information also.
No, but this annexure 1 is by subdivisional officer.
Sub-collector's order, my lord. This order of the Tahsildar was referred to the sub-collector who reflected the same thing in the order.
Then you see, the order has been passed by subdivisional officer Sadar Katak.
He is also not designated.
All right, this is therefore the order was not passed by Tahsildar.
Right. No, Tahsildar passed an order. Annexure 20, Lakshmi, can you see?
He might have passed an order, and based on that,
Right.
the subdivisional officer
Also
passed it.
passed an order.
So subdivision from the order, it appears that there is some application of mine. All right.
Yes, but same thing as in the Tahsildar's order, because inquiry conducted by Tahsildar
This is wrong.
based on revenue officer's order, revenue supervisor's order.
After all, 1 week
Yes, sir.
so as to enable.
Pardon, my lord. In this
Land.
matter, I file application for intervention, your lordship. I am the villagers.
All right.
I may be.
Very good.
You heard you can assist the court. You've heard what questions were being put.
More favor also. This is in my favor, your lordship, because that particular area is now used as the burial ground, your lordship. Government has taken so many steps.
The subdivisional officer Sadar Katak was notified as collector within the meaning of, for the purpose of section 5 bracketed I of Odisha State,
What is the State Abolition Act?
Odisha States Abolition Act, 1951. In respect of the, which area?
Is Vidyadharpur Katak.
Vidyadhar.
Which subdivision?
Subdivision is also Katak, lordship. Subdivision Katak.
Same then, now also same.
Yes.
Then also it was
It's only
Katak Sadar.
No, Thana Barang.
Eh?
Not Barang.
Barang.
I'm residing there.
Hmm?
In Vidyadharpur, I'm residing.
So Vidyadharpur is
Ward number 3 comes under ward number 3, but there is a separate.
CDA, we have not CDA towards.
no, but that
The
has
last
not
part
been
of CDA.
Nora's, towards Nora's,
Nora.
I will not sit there, Vidyadhar.
In fact, a part of it is from Athgad or something.
No, that is also part of it.
Ward number 3.
So this is the same Vidyadharpur as CRRI or?
No, no,
different?
CRRI is
That is what I was thinking.
Sierra is
Ward number 6, it ward number 3.
Sri University.
Okay. That bridge which we go that.
In fact, I was looking for the notification. Where is that notification?
Annexure.
notification is Annexure 18. Annexure 18. Phase 1. Phase 124.
Find out also if there is any
Yes.
previous or subsequent notification. Mr. Mishra, which page? Page.
Phase 124.
So this is not the only notification. This is apparent.
Time to time, different notification.
This notification is not the only notification.
No, there may be a number of notifications.
So that you have, Mr. Samantra, that you have to find out whether there is.
Yes,
subsequent
no.
or previous
That I
or
will
whatever.
No.
Humble submission, my lord. Let the copy may be served, counter copy and rejected copy may be served.
What right do you have?
Because I am for the intervenant into the matter.
So you make a request. Every intervenant does not have right to
My lord,
get a
my-
copy.
my-
Make a request, he may.
Because I have to say something because I am the villagers now using that particular area. It comes you using a my
That we have seen. The question is of jurisdiction.
my lord, jurisdiction point of view.
If you satisfy this.
I will satisfy your lordship.
Matter
And
will
next
be
date I will.
different. Otherwise, we may not interfere.
My lord. Date.
So, I request the learned lawyers to use that screen.
Actually, I was trying to do that. I have to learn actually.
Yes, you can, in fact, we can arrange this thing, kind of acquaintance exercise or.
It has to be a little bit down because our height is not that tall to.
That can be done.
Because
That
close
can-
to the. Yes.
That can be done.
That can be adjustable otherwise.
You're right.
This is fixed, not adjusted.
No,
No, we will
It
make.
can be, it is cut from the, not, low to 5 inches, it will be all right.
Like this.
Like which one?
Like this.
Oh, you mean, meaning the height?
Height.
Not
Height.
with regard to height. 2-3 inches, not it will do.
with regard to height man.
So you should have this. See, these are the issues which you should raise and you should tell.
Yeah.
See, we have this difficulty.
Very careful, in fact. If somewhere the finger goes there, something comes out.
No, you should use the mouse.
Yes.
The mouse also.
I'll-
You should
What
use
is-
if 2020 it comes. On next Saturday, we can do something. Or whenever after.
In fact, I got an iPad for the purpose of getting acquainted. Because I have seen a lot of advocates are using iPad in the court.
I was just going to say that junior Mr. Mishra can
They are expert in this.
teach you at home. Yes, you don't have to come here.
But it's good, sir.
Let us see.
Yeah.
In fact, just trying. It will be difficult. It will be easier for us to identify the documents.
Yes.
The moment you say
Correct.
the digital paper is this, let's see that.
Item 25.
25, my lord, we have Mr. Mishra appearing next week, my lord. He is ill, my lord, which,
As requested next week. 2 weeks.
Item 26.
Bye.
If I may, Your Lordship. Your Lordship, this is the second round for the petitioner approaching this honorable court, challenging the inaction of the opposite parties for not refunding the amount that is being paid by the petitioner for the operation of the stone quarry lease, Your Lordship. Your Lordship,
What had happened in the first round?
Your Lordship, in the first round, the transit permit was not issued to the petitioner. Hence, the petitioner approached this honorable court. And Your Lordship, if the Lordship may scroll down to annexion number 2 is the impugned judgment, Your Lordship. Para 6, Your Lordship. May be permitted to read, Your Lordship.
26.
14367. You want us to read which page?
Your Lordship, page number 45. Annexure 2, Your Lordship.
Yes.
Your Lordship, para 7. May be permitted to read, Your Lordship.
We were agreed.
If you're not willing to extend, you refund everything.
Similar matters were there before lordship today.
Yeah, so this happened in the first round. Then what happened?
Your Lordship, they have not paid the entire amount.
File a
Lordship-
contempt.
Your Lordship, we could have filed the contempt if they wouldn't have complied the whole order, Your Lordship. They have paid half, Your Lordship, and there needs Your Lordship, there need an adjudication between regarding the payment of the amount. Your Lordship, as per to the rule 32(1) and 2, the petitioner is liable to pay either the royalty amount or the dead rent amount.
Or the
Dead rent amount, Your Lordship.
yes.
But the petitioner has been charged both the amounts, Your Lordship, and he has paid both the amounts.
Yeah.
That needs to be adjudicated, Your Lordship.
That needs to be adjudicated.
Yes, Your Lordship, like the amount that is to be refunded to us, like whichever the highest amount, we need to pay that amount only, but we have paid both the amounts. So when there is a refund, so the amount that is to be paid back to us, that needs to be adjudicated.
And other dues shall also be refunded.
Yes, Your Lordship. But Your Lordship, they have only paid the district mineral fund only. Other amounts have not yet been paid.
The refundable amount, they are refunded.
Yes, Your Lordship.
I'll obtain instruction, lords may grant me sometime, find out lords, why they lords not lords comply lordship's order.
4 weeks counter affidavit. Let us see. Accept notice. Also accepts notice on behalf of the opposite party.
Item 27.
Obliged, Your Lordship.
27 and my lord, pray, my lord, tomorrow, my lord, on behalf of Mr. Naik, my lord.
No,
He's
let us
out
see
of-
what is the order.
They have to file the SOCOS, my lord. The SOCOS copy has also not been solved, my lord. It is in the noting that they have filed, but that has not been solved. I pray, my lord, tomorrow only.
Because I filed the so-cause. If my friend has not got a copy, I can give it. But I've stated therein was that we have already approved the Honorable Supreme Court in SLP. I've given the details of the SLP lots in my counter affidavit, so-cause affidavit.
Yes, the SLP has been filed, then what can be done?
My lord, I pray only because this is Mr. Naik's brief. He is out of town, my lord. He only telephoned me to adjourn the matter for tomorrow. Tomorrow, maybe.
I request on behalf of the petitioner. That will be tomorrow.
Item 28.
May I please, your lords? My lord, the order dated 20 February 2023 has not been complied with.
Where is that?
Order is at annexure 1. Your lordship may kindly see page 8. And the order is at page 9, paragraph 3.
Lordship had directed him to appear through minutes of hybrid BC to, and in fact, I have communicated the Lordship's order to him minutes also.
Who is he?
Tahsildar, my lord.
Lordship, I have communicated the order to the Tahsildar on 27/5/2024. This is the letter modified memo number we have communicated to the Tahsildar to be present through BC mode, my lords, to hear the charges. If your lordship grant me some 10 to 15 minutes, I can find out from my office whether he has given any copy.
We will take up the matter tomorrow.
Yes, ma'am. No.
Item 29.
Just
Apply the order.
despite the court's order. The Tahsildar, which area?
Yes, Tahsildar Dhenkanal, my lords.
Tahsildar Dhenkanal has not joined the online, joined the court proceedings online. So stop. This matter was directed to be listed today. Contempt matter was directed to be listed today for initiation of contempt proceeding against him with framing of charge. Stop. List this matter tomorrow. If the considered so and so does not join, the court shall be compelled to issue warrant of arrest for his production in the court. Either personally or through visit. Okay.
Yes, immediately, Lord. Yes. Right, Lord. He will come tomorrow in person, please.
Item 29.
It's in item number 29. The lordship's order has been complied with, and the amount was disbursed in favor of one person who is working in the still there in service. So far, others are concerned, Milords, because they have retired, Milords. Now, letters have been issued by the headmaster to give the details so that the amount can be paid, Milords. My friend can also obtain.
Your lordship, put up next week, call it next week. I will take instruction in the meantime, my lord.
So they have complied with the order.
No, as per my instruction, they have not paid. Only one person they paid. So your lordship put up next week. In the meantime, I will take instruction whether.
If your lordship sees the letters, Milords.
They are explaining why they could not pay, so they have complained.
Yes, for that reason, I also take instruction. We will dispose of the case whether for that reason, your lordship keep it pending. I will instruction. Take instruction.
Keep it pending till what?
Next day.
We are not executing courts. All right, we just ensure that the orders are implemented and the conduct of the party is not such that that amounts to contempt of court. That's all. All right, as requested on behalf of the petitioner, list this matter on 1 week. Most of the court expects that in the meanwhile, the contenders shall ensure that.
No, Milords. Here we have amount has been sanctioned, amount is lying with the DO, and the person who is not, because they are the area benefits, Milords. Out of 11 persons, person who is still working in the institution, he has received the amount. The others, those who retired, Milords, they are staying in their village. Notices have been issued to them, calling upon them to produce some documents like passbook number, ID card, other things, so that amount can be paid. So if you see next week, if they don't supply, Milords, so we may be at difficulty to comply lordship's order.
Sure.
No, yes, I will that take care of it.
The amount that the petitioners are entitled to are paid to them if they furnished or have already furnished the requisite information.
Requisite documents called for by the
documents, public information for payment.
No.
Will that do?
Yes, Milords.
Next week,
Item number 30.
man, obliged.
Item 30.
Where is Mr. Behra? Does it mean it has been complied?
Milords, we have complied, we have sanctioned the amount, Milords. If your lordships look at.
First order. On 1/5, time had been allowed for full compliance. This has been filed online or you not filed it?
No, I have not filed it. The documents I'm showing that amount has been sanctioned on 10/5/2024. If your lordships next document, they
Has been dispersed.
the director has sanctioned the amount. 31 lakhs 44,000.
Last paragraph says it has been paid.
Yeah.
There is no representation on behalf of the petitioner. Learned PGA appearing for the contenders as stated based on instructions that this court's order, violation of which has been alleged in the present contempt application, has been fully complied with. Stop. it appears. As the interest in the present contempt matter, stop this contempt, the contempt proceeding stands stopped accordingly.
Item 31.
31 on last occasion, your lordship, I have taken time to take instruction in the matter. Before going into the instruction, I'd like to place a brief fact that earlier the petitioner has sent proposal for sanction of his Sodhar home, but that was rejected as the address given by the petitioner was wrong. Therefore, his proposal was rejected. Thereafter, the representation he has given representation to consider his proposal. But now, in the meantime, this Sodhagriha and Ujjwala homes have been merged and renamed as Sakti Sadan. And that in that scheme, the funds are directly released to the states, and the state government has to implement this scheme. So it is the state government who has to send the proposal to the ministry, and that has to be approved in a program approval board. Immediately after the order was passed by this honorable court, the ministry has sent a letter to the state government to send the proposal. After that, one proposal approval board was also a meeting was held, and proposal was other states has sent their proposal, but state of Odisha has not sent any proposal. Therefore, the petitioners that has not been considered, could not be considered. Petitioner's proposal could not be considered, and that is the instruction that I have received.
So where is the direction?
And the direction is page 12. Page 12, last 5 lines.
Both of you are appearing for the petitioner? Or?
No, I am appearing for the petitioner.
And she's appearing for the state. Go, the Lordship, Union of India, central government.
Last 5 lines. See the
paragraph?
My lord, para 7, last 5 lines.
Yes.
See the representation of the petitioner under Annex so and so form part of the petition. This code directs that opinion number 1 shall take into consideration the same and pass appropriate order in accordance with law, because there is a need of Swadhar home or short stay home, or both, as the said solemn conscious decision has been taken by the project sanctioning committee within a period of 3 months from the date of production or communication of the certified copy of the order. My lord, earlier there was a sanction made by the government of Odisha that was sent. Inadvertently, they sent back without going to detail the matter. So we approached this court, honorable court, and the honorable court was pleased to direct this. So in view of this direction, they should have considered. Right now, they have come up with another thing that is not within my knowledge. Let them serve a copy on me. Let me.
No, that is her instructions. Instruction on that. There the stand was that your representations have not been received. So the court said that the representation which have been filed along with the writ petition, that will be taken into account.
Yes, I have sent. Order has been sent.
Along with that.
So let them, if they want to file a counter affidavit, they may file and serve a copy on me so that I can take step in the matter.
Will take into account and pass appropriate because there is need of, as the steps.
Who are you?
My lord, I am the organization which wanted to establish the unit. It is a registered body.
Have you filed PIL?
My lord?
Have you filed PIL?
No. It's a personal.
And what right do you have?
My lord, the organization has applied for it Because as per the scheme, the organization should apply. So organization applied. The scheme launched by the Government of India was that the matter should be considered by the state government, and on the basis of the recommendation of the state government, it will be granted. So in my case, recommendation has been made by the state government, but it has been illegally rejected by the central government, for which I approached this honorable.
No, it illegally rejected means it was rejected on the ground that
Different
address
address was there.
Address was wrong.
But address was not, my address was correct.
But not located in that.
The wrong location has been taken note of. Although my location was
their mistake.
All right.
And now the state government has to send the proposal again for sanctioning of that Swadhargriha home. For that twice letter has been sent from the central government.
No, but C is is seeking quashing of your decision.
Yes, Your Lordship. But
How do you justify your decision?
Your Lordship, until and unless the state government gives the proposal, we cannot sanction that. Whether there is a need
No,
of
the state government, this is the submission that the state government had given the proposal.
earlier in 2011.
2011.
And as the address. In the meantime, twice letters have also been sent to the state government.
Yes, one problem is that they have rejected it. And the Lordship were in session of the matter and directed them to reconsider. Because this annexure 11 is the fresh direction to reconsider. And 2011, there was a recommendation by the state government. Until and unless they make a fresh application, so much it may be
So
difficult.
that application has gone to the central government.
Because Lordship says, my friend may give those letters so that I can write to the authorities to act upon the letters issued by the Government of India. Because she has not given the letters by which the state government has requested by the central government to look into the letter.
Is there in Annexure 1, Your Lordship? In the contempt, it's an Annexure 1. Letter dated 25/4/2023. Page 9.
Around 4 weeks. So as to enable council representing the state of Odisha to seek instructions as regards the action taken pursuant to a communication dated 25/5/2023 made by Ministry of Women and Child Development addressed to the Director Social Welfare, Women and Child Development Department, State of Odisha. Which has been brought on record by way of Annexure 1, the present contempt application. Take instruction.
Yes, please. Thank you.
Please.
Item number 32.
What is this Swadhar?
Swadhargriha.
Swadhargriha.
Sudhar or Swadhar?
Swadhar.
Short stay home for women.
Like that. Like that.
Short stay for women.
Women and children.
Women and children. Under which provision? Are there any statutory provision or?
Statutory, the scheme has been formulated to give them shelter. Those who are left, who has been driven out of the house.
That means
who are suffered from the rape and other victims of.
So temporary or permanent or what is it?
It is temporary, not
temporary. Yes, during cases.
Immediately, some relief should be granted.
Rescue there sometimes. Pursuant to order of the.
Yes.
Yes.
Item 32.
Appearance may be noted, Your Lordship.
Lordship, in item number 32, I am appearing virtually in this matter. Lordship, I have filed this contempt petition owing to non-compliance of order dated 19/4/2023, Your Lordship. I have subsequently filed two representations, one on 8th of May 2023 and another on 7th of November 2023, Your Lordship.
You are Prativa Manjari Pradhan,
Yes, Your Lordship.
but it says advocate some Kalol Das.
No, Lordship, no, I am advocate for the petitioner, Your Lordship.
No, petitioner, you said you're appearing personally. That is why I'm asking.
No, Lordship, I'm appearing for the petitioner advocate.
Representing the petitioner. All
Yes, Your Lordship. Yes, Your Lordship. Your Lordship, there is non-compliance of order dated 19/4/2023, passed in writ petition number 16648 of 2022.
Mr. How will we get rid of this situation?
Sir, in most of the cases that was disposal of representations was. I think in the meantime, it must have been disposed of. So in many cases, it has been disposed of, but the contempts are filed. I'll find out. I'll also give you 2 days time.
This is disposed of, but because their order of choice has not been passed, so they file contempt.
And in some cases, they don't.
No, at least in such cases where you have disposed of the representations, you just give us a list, we will notify those applications. Let us do something with the number which is unnecessarily being shown in the independency of cases.
Yes.
So even if the applications are not listed, you get instructions.
That in fact, if I'll also say,
Odisha High Court must be the only high court in the country where 10,000 contempt applications are pending.
Right, madam. In the meantime, we'll also have disposed of many cases.
Tell them
Yeah.
that this has become common phenomenon. So if they don't implement all the orders, then the chief secretary will be will be convicted, may be convicted.
Right. Yes.
Unnecessarily, we are struggling with a huge number of cases. If the direction is for disposal of representation, dispose it off. Or you could have a post that we cannot dispose of so many of representations. 10,000 contempt applications in one high court and no conviction.
I think month of September, October.
Yeah.
Hey, there was one such case. Is it pending or disposed of?
That is pending.
That will take care of so many.
Yes. That is a PL, so much PL.
So much PL.
Yes,
All right, we will see. We will see.
Yes.
Let us please assist us.
Yes, sir.
Because we need to get rid of this situation.
Well,
this is for last 4 months, despite my best of my efforts, I have not been able to address the issue. Today, when I came, the pendency was 10,000 something. Today also the pendency is 10,000 something. Because
Because one thing may I say, so far as division bench contempts are concerned, the number is very less. So far as single bench contempts are concerned, it must be more than 8,000 turnover.
8,000?
And above single bench contempt applications now pending before this Honorable Court, maybe 8,000 and odd.
So now all the contempt matters will come before this bench.
No, I'm not saying that.
Yes, that is what I have done. That now all the contempt matters, wherever they were earlier listed, all of them, all such cases will be listed before this court.
Right.
So let some officer be convicted,
yes,
punished, then only we think the situation may improve.
So you get instructions in all the cases which are there, not only
You
when the court asks.
So you can just tell the court that these are the cases in which the orders have been complied with. We'll get those matters listed and dispose them off at
Yes,
list.
sir. So each time also in the meantime, I'll obtain instruction.
Well, counsel has requested on behalf of the AGA list this matter on 2 weeks so as to enable him to seek instructions as regards compliance of this court's order dated 19/4/2023.
Item 33.
Obliged, Your Lordship.
Second contempt. This is the second round contempt.
Yes.
They have not complied the order passed in the writ application. Therefore, I have filed the contempt.
What was
In
the order?
contempt, 3 months' time is also allowed.
What was the order?
Order, my lord, at page 1, my lord. Annexure 1, at page.
What was the order?
Order is to consider the representation.
Consider his representation.
Yes, here also not, so I'll find out.
They are land housey. These people are the land housey.
Maybe land, whether you are land housey, whether you are entitled to any compensation or not, that we could have decided.
Yes, yes.
We are here to decide.
That's why London can take instruction. That is the purpose will be solved.
Ask the chief secretary to be here personally, because the situation is beyond control. Tell us tomorrow. The matter will come tomorrow. Ask the chief secretary when either he may come tomorrow or day after tomorrow. If he
Day
comes
after tomorrow
it's
also.
okay. Otherwise, considering huge number of pendency of contempt applications, mostly relating to the mostly concerning directions issued by this court to the authorities to dispose of representations, we require personal attendance of the chief secretary Odisha in court on. We require Chief Secretary Odisha to join the court proceeding online on Wednesday for him to inform this court as to how use pendency as to how does he propose to ensure that such orders are complied with within a time frame.
Well, so we fixed it at 2 o'clock.
2 o'clock.
Yeah.
Day after.
Oh, sorry, Wednesday is tomorrow.
Thursday.
Thursday, yes.
Yes.
Oh.
Tuesday.
On 20th. Item 34.
May I please your lordship? My lord, I am in VC, my lord. My lord, it's a non-compliance of the Honorable Division Bench Order of 13/7 and 2023.
What is the order?
My lord, the order was to dispose of the OEA case number 1837 of 2016 pending before the Tahsildar Puri within 6 weeks. The order was from 13/7/2023, my lord. In between 1 year has been elapsed. My the order was in Annexure 1, page 11.
Disposal within 6 weeks. OEA case.
My lord.
The year 2016. 6 weeks.
What was this OEA case about? What is this OEA case about?
My lord, yes, it was a pending case of 2016, my lord.
What is OEA?
Odisha State Abolition Act, my lord.
So what was the case before the Tehsildar? What was to be disposed of?
But the main case was being targeted by the honorable court to dispose of within 6 weeks, my lord.
Possible to dispose of 6 weeks. What is the stage of the OEA case when you had approached this court?
My lord, it was about to over, my lord. Actually, I was not the conducting lawyer in that main writ application, my lord.
Writ petition is here.
Seek instruction.
Yes, yes, yes.
As requested on behalf of the contenders. This matter on 8 weeks for him to report full compliance of this course. 13/7/2023 passed in WPC number 4740 of 2023.
So Samantray, when these applications are disposed of, directing for disposal of representation, does your office communicate the order?
Most of the cases they do not, because there is a direction for them to produce the certified copy of the order before the concerned authority.
Not always.
No, many of the cases there is order in order. So I think we may not have complied the.
Yes.
Item 35.
Much obliged.
May I please, Your Lordship? Order dated 8/2/2024 has not been complied with. The direction was made to consider the letter dated 13/11/2023 within a period of 3 weeks. And that letter regarding the trust board was formed and it was approved on 4/10/2023 under the OHR Act. And the interim managing trustee was elected and it was approved on 2/11/2023. But de facto interim managing trustee did not hand over the charge. So resolution was passed by the trust board and it was intimated to the endowment commissioner on 13/11/2023 by the present interim managing trustee to take action under section 12 of the OHR Act.
Who has committed the contempt?
And that has the charge has not been handed over to the interim managing trustee present.
So who has committed? Which contender?
Opposite part number 2, my lord.
Who's it?
Commissioner of Endowments.
Commissioner of Endowment, my lord.
So Commissioner of Endowment should be convicted.
Pardon, my
Commissioner of Endowment should be convicted.
Yes, my lord. Should comply the order.
No, this is contempt application.
Yes, ma'am.
So we should convict him, the Commissioner of Endowments.
Yes, ma'am.
Whosoever is there.
Lolatendu Jana was the commissioner. At page 2 of my contempt application.
Page 2.
Cost title.
Cost title.
So impleted the law secretary and the commissioner.
Law secretary is an IS officer. He is not OSJS. He has been described as IS officer.
And Mr. You want us to convict Commissioner of Endowments.
He has not complied with the order, Commissioner of Endowment.
So if today Commissioner is transferred, then what will happen? The transferred Commissioner will be convicted.
Pardon?
See, you have implemented him by office, Commissioner of Endowments, not by name.
By name, I have implemented.
Contain them also. Sorry, I missed.
No.
What is that averment in paragraph 4? That was also for disposal of, not for handing over charge.
Nay,
Read your paragraph 4.
Order letter dated 13/4, the second page of the order, to consider the application of the petitioner stated to have been filed on 13/11/2023 in its proper perspective and dispose of the same in accordance with
Yes,
law.
yes.
That 13/11/2023 letter is the present interim managing trustee has sent this letter to the endowment commissioner to take action under section 12 of the OHRE Act to hand over the charge since 2/11/2023. The de facto interim managing trustee is not handing over the charge to the present interim managing trustee, who is newly elected, and it was approved by the endowment commissioner.
No, that was for disposal of your representation. Was the order that they should
That is
hand
not
over
the
charge
representation, that is the letter in annexure
to hand over
in the
charge?
writ application.
What is the order in the writ
in
petition?
the-
What is the order?
In the order, it has been mentioned that to consider the application. That is the letter of the present interim managing trustee.
Consider and come.
To take action under section 12 of the
8 weeks.
OHRE Act.
So as to enable an AGA to seek instructions as regards full compliance of this court's order dated 8/2/2024, passed in WPC number 1695 of 2024. 8 weeks, let it come.
Yes.
Now, within 1 month,
Yes.
either the orders are complied with,
Right, ma'am.
or some top official
Yes, ma'am.
will go to jail.
Right, ma'am.
Please.
This one. Chandigarh.
Yes. Yes, next.
Item 36.
May I please, Lords? On behalf of P. Mahapatra, I am placing the matter. The order dated 13/12/2023 has not been complied. It is operative part, may I read, my lord? Operative part of para 10. In the above view of the matter, page 13, para 10. In the above view of the matter, the order impugned dated 25/1/2023 in Annexure 8 cannot sustain in the eye of law, and the same is liable to be quashed and is hereby quashed. The matter is remitted back to the opposite part number 1 to reconsider the same in the light of the judgment of this court in Raghunath Sahu Supra and pass appropriate order by affording opportunity of hearing to the petitioner in accordance with law as expeditiously as possible, preferably within a period of 2 months. This order has been passed on 13/12. And it has been communicated to the contemptor, that is 21 December. Till today, this order has not been complied with.
What is Raghunath Sahu?
That is a price that has been discussed, mentioned in page, page 11, para 2020, and that is mentioned. That is price exclamation contract of this matter. Page 11, para 2021.
So what was held in Raghunath Sahu?
The operative part, my lord, page 13, paragraph 25. Considering the facts and law as discussed above, this court is of the considered view that the opposite parties are liable to pay the blockage amount of rupees 4,20,940 towards escalation costs as per the bill submitted on 27/8/2002, along with interest at the rate of 12% per annum, with effect from 22/8/2012 till the actual payment is made. As such, the payment shall be made within a period of 3 months from the date of communication, production of the judgment, failing which it will carry further interest at the rate of 18% per annum, with effect from 22/8/2012 till the actual date of payment. That is price escalation money.
That means where extension of time has been granted, which is not due to your fault.
My lord.
So that was decided or that was?
Escalation cost which is not due to the fault of the petitioner, it has to be granted by the authority. That is the also agreement. Where in case where there is the contractor is at fault, he is not entitled. That is the Raghunath Sahu judgment.
That is all right. So this has been disposed of on the first day.
Yes, ma'am.
If you have to comply, you have to comply. If not, you have to challenge.
Right, ma'am.
Yes,
so,
sir.
Also, may only give a week's time. I can obtain instruction whether it has been challenged or complied with.
Undertaking is nothing but a standard form. All right.
Yeah.
As requested on behalf of the contenders, discuss matter on 8 weeks to seek instructions.
Item 37.
May I please pause? The connected writ application out of which this contempt arises, my lord, was relating to the rate of levy of royalty, my lords, for the period GST on royalty for the period 1/7/2017 to 31st of December 2018, my lords. So if your lordship would, lordship's order is at Annexure 1, page 9. And may I just take your lordship's order to at page 17, the operative portion, my lords. The reasoning for after which the lordships at page 17 and paragraph 7 minutes. Let us place it minutes.
Validity of the certificate.
Lordship at page 17 minutes.
Yes.
Paragraph 7. having due regard to the rival contentions and submissions, it is seen that the circular is the basis for initiation of proceeding under Section 73 of the CGST-OGST Act. Further, the circular itself has mentioned at paragraph 9.3.3 that the clarification was issued pursuant to the recommendation of the Council, as there is no specific mention of service by way of grant of mining rights during the period 1/7/2017 to 31/12/2018. If the statement of the counsel for the opposite parties is accepted and the petitioner is given opportunity to participate in the proceeding, there may be every possibility for the proper officer to follow the recommendation of the council, pursuant to which the circular has been issued by the central government, which in turn was followed has followed the view of the Appellate Authority for Advance Ruling by order dated so-and-so in regarding penguin trading agencies. This court is not oblivious of the settled position of law that a substantive right cannot be put to jeopardy by bringing into operation fiscal law with retrospective effect. A reference may be had to CIT in Vatica Townships so-and-so, 2015-1 SEC, Jerem and Company, 2016-96 VST Supreme Court, Reliance Industries versus Commission
but
of
this is an interim order, no?
This is an interim order by virtue of which the lordships have said that we need not participate in the further proceeding of Section 73 of the CGST Act. That your lordship would get it at paragraph 8. In view of the above, this court is satisfied that prima facie
No, but where is the writ petition pending?
No, the writ petition is pending in the High Court.
Let the contempt petition and writ petition both be heard.
So what has happened, my lord, in spite of your lordship's order and the spirit of the order, my lord, that it will be an appeal from Caesar to Caesar's wife, that which your lordship will get it at page 18. Just second line. Because your lordship got it?
18.
Page 18.
Yes.
May I just place that page, paragraph, lord, so that your lordship would be... I'll place it from page 17, paragraph 8. In view of the above, this court is satisfied that prima facie case is made out as the petitioner has demonstrated that its transactions fell within the scope of the residuary entry of serial number 17 under the heading 9973, leasing or rental service with or without operator, which attracts rate of tax at 5%, CGST 2.5, OGST 2.5, which it has discharged liability for the transaction effected during the period 1/7/2017 to 31/12/2018, to which no objection is raised by the revenue. This court is inclined to admit the writ petition because if the petitioner is asked to participate in the proceeding under 73 of the CGST OGST Act, it would seem as if it is pushed from Caesar to Caesar's wife. And such a proceeding would be a mirage, being an exercise in futility, more so when the show cause notice is based on circular issued by the Government of India in the Ministry of Finance, Department of Revenue, Tax Research Unit, being CB so-and-so, dated 6/10/2021.
Whether this...
But in spite of this...
The amendment was under challenge.
The amendment was under challenge, and the retrospective operation of the amendment modifying the rate of tax from 5% to 18% was on the subject matter of challenge. There, the lordships have said that please do not, because I had approached this honorable court in a demand come show cause stage.
Sir, this is a very serious matter. You are challenging central legislation.
My lord, I am challenging
unless the legislation is held to be ultra virus, that will operate.
No,
the court cannot stay operation of
the court has not stayed the operation of the law.
Yes.
No, they have said that please do not, because I have already applied, they had applied the 5% rate, which was the prevailing.
Yes.
That was retrospectively amended from 2018. I had already paid that 5%.
Then
that's why the lordships have said that unless, because a host of writ petitions are also pending before this honorable court. What has happened, my lord? What has happened in this case?
Yes.
That their lordships have said that no further proceeding in 73 proceeding. And that is how, my lord, they have said that in the meantime, no coercive action for recovery of the demand of the differential tax. It's not that I have not paid. I paid that amount of 5%. It's a differential tax.
We will see.
And what has happened, my lord?
As reflected in the summary of show cause notice.
Show cause notice. Yes. So because I had approached in the show cause stage. Now, after this, by annexure, my lord,
we will hear your matter on priority basis.
No, your lordship would appreciate there's a violation of your lordship's order.
You cannot compel us to initiate contempt proceedings.
No, I
even
cannot.
if the contempt has been committed.
True, my lord. The contempt
here.
Yes, my lord.
How many matters are there?
No,
Only one minute. Only 1 minute.
no, no, no.
No, no.
About the royalty.
Six similar matters are there.
5 to 6 matters.
Give us the list. We
Yes,
will
I'm-
hear better.
We have already filed counter in this
And
case.
my lords, in this particular case, an IA is filed for modification of the order on the 26th of April. 30th of April, he
We have
passes the final order.
We have not enforced the demand. We have not enforced. That order was passed. We are not enforcing the demand. As it has been held in the
We
Sokas
make
notice.
it clear that even if in cases we find that the order has been violated, it is between the court and the contemner.
Yes.
So the forceful way in which you are making the submission.
My humble contention. My humble
We are
contention.
ready to hear your writ petition on merits.
But there's
We
a
will decide.
violation of this law honorable court's order.
Huh?
There's a violation of this honorable court's order.
We are more worried about that.
Sorry.
We are more worried about that because we are court.
Mallards. And the majesty of
It is not that only you are concerned.
No, my lords. It's my duty only to
Yes,
bring it
you
to
have
your
conveyed
lordship.
that. That's all.
My lords. That is my humble duty, my lords. And it's the majesty of the court also your lordship.
Don't repeat this word.
No, lords.
As if we are doing something with the majesty of the court.
No, lords.
We are lowering down the majesty of the
not
court.
at all.
We don't understand that.
No, my lords.
And you have to preach us.
My lords, in spite of an IA, my lord, they pass the order. 4 days. They pass an order.
Give the list of the cases.
Yes, my lord. I'll tomorrow.
Let this matter tomorrow under the same meeting. Learned counsel for the parties shall be required to supply list of
similar matter.
List of cases involving what?
Involving the imposition of royalty.
Imposition of GST on royalty.
Royalty. And, my lord, the retrospective amendment.
And
or the rate of tax.
We will see.
My lords. I'm sorry, my lords. My intention was only to bring that back to your lordship's attention. Nothing more than that.
Mr. Mishra, Mr. Char, you should always keep this in mind that contempt matters are different from other proceedings.
My lords.
So when you start preaching the court about the majesty of the court,
no, it was not at all my intention.
Yes, as if you were making your submission as if we don't understand what is the majesty of the court equally as you understand.
No, I'm sorry, maybe my
you conveyed to the court that this particular order has been violated. That's all.
I just wanted duty. What I wanted to say was it was only the background in which this order was.
We will see.
The lordship are calling it tomorrow.
No. Writ petitions.
Let's keep it next week.
Tomorrow you give us the list.
I'm giving it tomorrow.
So the moment you give the list of the cases, you'll fix a date and time.
Yes.
For final hearing of all those cases. So please prepare yourselves on the merit of the case.
Please.
All right.
Item number 38.
The direction dated 17/5/2023 has not been complied with. I've annexed that order with annexure 1 at page 16.
Yes, 1. Annexure, page 16.
Mile.
Is the order.
Mile.
Comply the order.
Yes, OP 7 is the contemptor only because there was a direction to OP number 7 only. I'll obtain instruction from OP 7.
All right. 4 weeks.
Orders item 39.
There is a delay of 54 days. File the appeal.
Yes, we saw the other side.
Government is the other side.
Yes.
Delay control.
And so far other defects are concerned, my lord.
इतना ही नहीं लिखना है लिखो आइए number so and so this application has been filed for, no, but your appeal is otherwise defective.
No, that, my lord, I will pray for time, my lord.
So first remove your defects. Let the defects as pointed out by the stamp reporter be removed within how much time?
Lords may kindly give me, my lord, 1 week time, I will verify what are the defects.
All like 2 weeks. Stop. IE number 367 of 2023. This application has been filed for condonation of delay in making this appeal. Stop. There is delay of 54 days.
Yes.
In preferring the present intra-court appeal. Stop. Considering the facts asserted in this application, in our opinion, case is made out for condonation of delay. Stop. Delay stands condoned. IA number so and so stands allowed. Yes.
No private party. No private party.
No, it is grievance against the government, my lord.
No, whether any private party.
At least the governing body is there.
Then without noticing governing body, how can we condone the delay?
Governing body of the college there. Then, my lord, your lordship may issue notice, my lord. Only to
Order card there. Issue notice.
OP3.
OP2 and 3.
Planet. AGA.
2 and 3.
Director is.
Governing body, I can receive only for 1 and 2.
So accept notice on behalf of
1 and 2 and 4.
President. Yes,
opposite
President,
party
I can.
number 1 and 2. So issue notice. Opposite party number 3 and 4.
4 is, my lord, sub-collector.
As president, you have already me as president of governing body.
Sub-collector come president. Then it has to go.
Refugees, my lord, I will try to.
1 week.
Item number 40.
Again, defect and copy. It and what is not there. Sometimes there's some defects.
Item 40.
There is no representation on behalf of the appellant. Stop. Let the defects as pointed out by the stamp reporter be removed within 2 weeks, failing which this appeal shall stand dismissed without further reference to bench.
Item 41.
There is a delay of 330 days. The case regarding that RSCP, my lord, Lordsmith, very short point is involved. We have Lordsmith turn to page 14 only. Very small point is involved. Lordsmith see the Honorable Court has granted third RSCP with effect from 8/6/2015. Lordsmith, page 14.
Page 14.
14 my lord.
Yes.
That's Honorable Court has granted third RSCP with effect from 8/6/2015.
8/6/2015.
My lord. Then my lord, I will draw my lord's notice.
RSCP.
Third RSCP revived assured career progression.
Yes, third RSCP granted.
Yes, my lord. Then I will draw my lord's notice to page 3 of my writ appeal. Para 4, my lord. You will also see para 4. She was appointed on 9/8/1986. Let's got it.
Yes.
So as for the RSCP, one is entitled to third RSCP on completion of 30 years of service. So he to complete that, respondent is to complete 30 years on 7/8/2016. very small, that is the only point. When he has not completed 30
No,
years.
but what is the reasoning given for this?
If-
Whether any reasoning has been given?
No, no reason has been given, but I have.
Come to the court as being granted third RSCP, which is not.
No, but there may be typographical error.
No, not typo, but perhaps what has happened, in similar cases, order has been passed and submission has been made as they have been denied RSCP, as other persons have been granted RSCP, he has been denied. So only on the basis of that submission.
Submission has been made that those who have come to the court have been
Yes,
granted RSCP.
that submission is made before the honorable court and the court has granted third RSCP.
All.
And limit, you'll ask me issue notice on the question of limitation because. Right.
So, okay. Because of limitation and the main matter.
Item 42.
Because of contract.
IE number what is the
2146.
IE number 2146. This application taking dispensing with the filing of certified copy of the impure order stands allowed. That's all.
You prayed for time that for the time being, later you'll get.
I'll file that in the meantime, I'll file that certified.
File it, but within a particular period.
The Lordship will pass that order, in the meantime, I'll file that.
The prayer is, the certified copy of the order is brought on record.
I'll file this.
Dispensing it is allowed.
Yes.
Item number 42.
Number 42. In this case, there is a delay of 373 days, my lord.
Why?
And so far as the merit of the case is concerned,
There is no merit.
the job.
If a similar matters, Lordship has issued
Issue
notice by
job contract
issued notice that job contract matters on all matters were dismissed here on the ground of limitation. That was challenged before the Honorable Apex Court. And Honorable Apex Court has stayed it. Thereafter, your Lordship has issued notice on the question of limitation.
All right. Issue notice. Limitation. Limitation. Issue notice on.
Also dispensing it.
You can dispensing it, but dispensing.
Are there any connected cases in which it should be tagged or not?
Yes, the number of writ appeals are there. I will give the number tomorrow. I will give them.
We'll check.
Item 43.
43, my lord, there is a delay of 410 days. There is the Honorable Court has directed to consider the date. Consider the date for arrear dues from the date the petitioner was brought over to the regular establishment. But the petitioner joined the regular establishment with effect from 1/10. So whether he is entitled from the date when the order was effective, but he was not joined. He joined in a later date. So that is the only question which is to be considered. And as per the work charge establishment rule that is enclosed to the writ petition, your Lordship will find at page 24 the definition. Your Lordship will find pay means an amount drawn monthly by an employee for the post held by him. So even if the notification was issued, that was the petitioner joined on 1/10/2009.
So that's what is the difference? Manoj, what dates did you say? Order was work charge establishment on which date?
Work charge establishment, he was brought to the work charge establishment. If your Lordship will look into the list of dates that I have enclosed, that is at C. If my lords, the LOD. Your Lordship may kindly have a glance to serial number 3. Serial number 3, my lord. 1/3/2009. In terms of the order dated 3/4/2010, the NMR employees like the respondent were brought over to the work charge establishment with effect from 1/3/2009. So the order to bring them to the work charge establishment was issued on 3/4/2010, but it was given a retrospective effect from 1/3/2009. But from 1/3/2009 till 3/4/2010, these petitioners haven't worked in the work charge establishment. So they are claiming the arrears for that period for which they have not worked. And so far,
it has been allowed.
REIT has been allowed in terms of the order passed in case of Lakshmidhar Mahanta.
What is there in that order?
There the Honorable Court has directed to grant them the benefit from the date the order was given effect, irrespective of the fact that whether the person concerned has joined from a later date or not. No.
What was the justification for not joining? No, reason given for not joining.
That judgment I have not. That judgment I have not enclosed to the writ appeal.
So tell us tomorrow.
Tomorrow.
As requested on behalf of the appellant. List the matter tomorrow under the same heading.
Item 44.
Yes,
Well, item 41, that is job contract similar to my lord item. कितना नंबर था? 42.
How much delay? Same.
Yes, ma'am. The delay is different. But that is regarding that job contract employees pension from the date of enter service is to be calculated. This is the case, my lord. That rule says there is any shortfall that will be counted for the purpose of minimum pension. The Honorable Court has directed to count the entire period of job contract period to get to treat as qualifying service. So all those matters in Honorable Single Judge order was challenged here in writ appeal. Some of the cases were dismissed only on the ground of limitation. That was challenged before the Honorable Apex Court, and the Honorable Apex Court has stayed those orders. So your Lordship has issued notice in all similar matters. I will give the numbers tomorrow, my lord.
Issue notice limitation matter.
Well,
Item 45.
45, that is a case of regularization, the 330 days delay.
Outstanding. Item 46.
45.
45.
Issue notice. Limitation.
Well, item 46.
Looking back. 42 and 44.
Yes. 42 and 44 are
This is 44 fully. Is this matter along with 46.
Item 46.
My lord, 46. It's a case of regularization, and there is a delay of 471 days.
It means your officials are also interested in somehow or the other they cooperate.
filed on.
The filed on 1/5/2023.
We'll see, issue notice.
None.
What 47 also same. 46, 47.
47.
47.
47. Along with 45. Dispensing with petition, Johan.
Allowed. Item 48. Ticket.
The 150 days delay, my lord.
Issue notice. Limitation.
At these cases, because limitation is there, my lord's order is there only whenever one appears for respondent, your lordship is remanding those matters. But there is a limitation, your lordship may issue notice. That is Sartaparida case. Right? That is Sartaparida case, that pension in regard to employees of block grant schools and colleges. In those cases, your lordship is remanding those matters to the Honorable Single Judge because no opportunity has provided to us. Here, my lord, there is a limitation. So in those cases where limitation is there, your lordship is issuing notice on the question of limitation. In this case, 150 days, your lordship may issue.
Issue notice. Yes.
Item 49.
Item 49 is similar to my lord 46 and 47. Yes, ma'am. State about it that the regularization matter similar principle that they were appointed after 1993 seeking regulation, and on the date of first day this was disposed of, taking the issue of that judgment of Honorable Apex Court in the case of Uma Devi, my lord. That on first day we have not been given opportunity because we have a scheme that those who are appointed after 12 for 1993, they cannot be regularized. Those who are that yes, that is final department. There is limitation.
Issue notice limitation. Where is your limitation? IA 2278 or 2277 dispensing with.
Item number 50.
Item 50, 51, 52, all are Sartaparida matters. All are that pension that is similar to item 48. (50), 51 and 52.
51. Issue notice. List along with
42.
40. Dispense.
Item number 54. (53)
53, that was withdrawn.
Item 54.
May I please, your lordship? My lord, I am appearing on behalf of Mr. P.C. Das.
So remove the defects first.
Right, my
2 weeks time is allowed for the petitioner to remove the defects. What is this matter about?
Illegal-
Public interest litigation, your lordship.
illegal encroachment of the.
No, the encroachment we are disposing it of. Oh, the defects pointed out by the stamp reporter stand ignored.
Petitioners were disengaged. The respondents were disengaged from service as they.
Someone is appearing for the other side. You are appearing.
I am at the instruction, my lord. I could get the code. I'll file the power, my lord. It is
You
there.
file power first.
That is the problem. I have sought for this.
Do it.
Kotsi only I'll file it in course of the day.
Good.
That
We'll
only
here take up the matter on Wakalatnama is going to be filed. It is
today in
stated
course of
that Wakalatnama on behalf of on behalf of the, no, which respondent?
I have no copy. He is to serve a copy.
Which respondent?
No, only with the, it's a Binay.
One respondent.
Binay
Binay Ranjan Parija.
Binay Ranjan Parija.
Yeah, for respondent is going to be filed latest by tomorrow. This matter on Thursday.
Well, one more problem. There are common judgment, two other writ appeal filed by them. These are the numbers are 1261 and 1327 of 24. Can it be taken up together so that same judgment, man? Two other person. I was the counsel.
He is right.
Yes. You have filed.
No, but what is the stage of?
They have filed it. I have got the number from the net. This one,
I'll have
three
to
cases.
verify. I'll have to verify, madam.
Let us.
No notice has gone in that.
We'll pass. See, if those appeals are fit for admission, then the matter is different because in your case, we have not considered the limitation aspect.
Okay. Same.
So we will see.
One more, another writ appeal filed against the same judgment by the private respondents there. That has order been passed by my lord and other bench also, coordinate bench. That is there. Government was hard. Yes, issue settled it, set at rest by the division bench also. I will file the first day, my lord.
Do you have the idea of those orders?
Probably he don't have the idea. Because Mr. R.N. Mishra, as I find from the record, Mr. R.N. Mishra was the counsel in the earlier writ appeal. He is the state counsel. And this petition, his name is also reflected in the cause list. Mr. R.N. Mishra. Yes. Probably because the number of cases there might have.
Please let him, please give the orders.
Mr. Das might not have. No.
And the orders which have been passed by this bench and the coordinate bench.
My lord, what happened? Initially, we were terminated. Our services were terminated. We have challenged that and I have succeeded in the single bench. Some other person, they say, apprehend that if we will be reinstated, they will be ousted from the service. They challenge it. They were in the writ petition as well in the writ appeal. But the Honorable Court has said you have no conflict of interest with these persons. Because we will go in our own way and you are continuing in service. So, accordingly, the writ appeal was disposed of. Same order.
Because they will not be affected, that is why it has been.
That was the order, but my responsible submission is the state was there. State could have done after 1.5 hours when I filed the contempt. In the contempt, this Honorable Court, my Lord Justice, Chief Justice, and sitting with my Lord Justice Raman, passed the order, you comply the order. That order is also there. Despite that, after a poor person, they are not one of the physical handicaps. Writ appeal number is 545 of
not now.
Yes, I will give it.
For admission item number 57.
Lordship, in item 57, RDC was supposed to file a detailed report, my lord. On the last occasion, they had taken 4 weeks time to file such report. Till now, they have not filed such. It was filed on 15/4/2024 by the RDC Sambalpur. I number 5311/2024. Order dated 16/4/2024.
Yes. That's okay. Yes, report is ready. I think they filed it online. I've got only one copy I've got because dated it 18/6 only. Today,
So if also you can get it, Lords, I've got a copy. He has given a report. Lords, you can look at, Lords, I've got the report.
Pending loan behind the boys hostel.
Yes, Lords.
Have you given him a copy of this report?
I have not given it. I can give a copy to my friend also, Lord.
So give him.
Yes.
File it, can you file it by way of affidavit?
Because Lordship had called upon the RDC to file the report. So he has given this report.
So what is his opinion?
Yes, I have not gone through, but I
have
think
not gone through.
he has stated that it's illegally done. Yes, I think so.
It's because we had requested him to file his report as an officer of the court.
Right, Nurse.
No, then not as an officer of the government.
Right, Nurse.
So has he taken that responsibility?
No, I think so, Nurse.
All right, please give him.
I will get it Xerox notes, so I will give copy to my friend also and 2 copies to my lawyer.
We will take up this matter tomorrow.
Tomorrow. No, I don't know because no, it's only 1 copy is there in my record, Milords. That's why, Milords, I'm saying that, Milords, I will get it, Milords, Xerox and give it, Milords. In course of the day, I will give it here.
Mr. and AEA informs that he is in receipt of a report prepared by the Divisional Commissioner, Northern Division, Sambalpur, in compliance of this court's order dated 19/3/2024, passed in this case. Stop. Let a copy of the said report be made available to learned counsel for the petitioner. Stop. List this matter tomorrow. Day after tomorrow.
Day after tomorrow. Item 58.
58, my lord, I pray the matter may be taken up day after tomorrow. 58.
Hey. All right. As requested.
Well, next to
On behalf of the appellants. List this matter on. When do you want?
Day after tomorrow, you lost.
Item 59.
And my lord, may I please, may I please, Lordship, and through BC, my lord, on the last date, your Lordship has issued notice. This matter relates to
Filing counter. Reminders, in this case, they're challenging the virus of a notification of the government concerning regularization of subdivided plots. Counter from the government is very much necessary. I am appearing for CDA. I also will be filing counter within 2 weeks. Government may also be required to file a counter so that it can be taken up for final hearing.
Yes.
Sure. No counter. I will also file a counter on behalf of the state blocks because I find from the records not Lordship is pleased to grant time to file the counter affidavit by the state also, my lords. But it has not yet been filed, my lords.
6 weeks further time is allowed for the state to file counter affidavit
I am for CDM, my lords. I will also file counter.
as well as the stop. Same time is allowed for the CMC. Full form requires Cuttack Municipal Corporation and Cuttack Development
Authority.
to file their affidavits. So, list this case on 6 weeks.
Item number 60.
Obliged.
But the order dated 16/4/24. Lordship and my lordship had taken notice on behalf of opposite parties 1 and 2, and your lordship had also issued notice to opposite party number 3 with the serpents. And notice is treated as sufficient. But my lordship had said the other day that you will see that order is complied. I do not know what instruction he has got.
So, in two cases, I have got the instruction in contempt number 2660 and another 244224. Status is preferred SLP minutes. That is the instruction. So far others are concerned, I will find out because first item is 2242.
I don't think notice has been issued.
No,
Notice has not been
SLP
issued.
diary number has been given.
Diary number, by keeping diary number, they keep it for years together.
So you may grant me some time. I have told
The order was passed when?
Your lordship,
24/4/2020. No. Order of the court,
Yes.
28/3/2023.
Yes.
Definitely.
After filing.
And in the
Of course, the direction is to the Sarpanch. In all the cases, lordship direction is to the Sarpanch. But somehow state has preferred.
No, because state has been your lordship. The other day also it was okay. State is the authority, sanctioning authority. State is to pay, and the sanction is only disbursing authority.
I am not saying
that. That is the reason why that.
Yes, I have not considered. I said so because there was a specific direction to the Sarpanch millers. I had order taken that because ultimately state has to give the money so that it can be paid millers.
Where is the direction?
If you also can look at the order at page
26. Last portion is at page 26, para 16.
Accordingly, along with repeats direct the OP number 6 in extending the minimum wage benefit under notification of such and such. So OP number 6 is the millers Sarpanch millers.
So where is the contempt?
Because they have not complied your lordship's order. That's the reason why.
Interest.
Sorry, my lord.
They have not complied with the order. You are earning interest.
No, interest, that is it. But that is the order, lord. But the poor persons, they are not given a single pie, my lord. They are not a single pie. They are working for months together, years together, but they are not getting a single pie. Yes. Yes.
Failing with 6%.
So the court makes it clear that failure of payment as per above stipulation shall not amount to contempt of court. Because consequence is mentioned.
No interest within that time, thereafter interest.
No, they will pay that, but the failure to payment after stipulation, person will be entitled to interest of. So that's the reason why because there are 3 writ applications earlier. 3 applications have been allowed, and their lordships have also relied on those judgments, and relying on that judgment, this judgment has been passed. By considering Contempt has also admitted.
See, just think from the perspective of a person who is going to be prosecuted.
Yes, my lord.
He may take this plea that, or is an officer, you take this plea that yes, we will give him 6% per annum. That is the consequence. That is what he understood by reading the order.
That he is not coming forward, my lord. That opposite party, despite notice, is not coming forward. Not coming forward. The notice has been treated as sufficient.
Yes.
Not coming forward. He's not, they're not appearing. And the government has admitted, the lordship has referred to the admission of the government.
So this
No, but yes, admitted, the lordship can see the government in the other case, my lord.
this order is under challenge.
This order, I do not, we do not know anything.
I've received a communication from the government in Panchayat Raj department that two SLP numbers they've given Millers. One is Millers in contempt number 2660 and another is 2242, the first contempt. And
Diary number. You said diary number.
Yes,
You
obviously.
just now said diary number. So diary number, by this process, diary number, they keep it pending for months together. That is the...
It gets automatically dismissed unless the defect is removed within 60 days, like our system also, it gets dismissed, also never listed before the court.
It has been stated at the bar that two SLPs have been two SLPs that and this SLP has been preferred before the Supreme Court against this court's order dated 28/3/2023, passed in WPC number 6871 of 2012.
No, that's it.
Yes, sir. Legal lawsuits to get the
Lordship can see that 21908 and 6871. Two specific WPC. Other one is 21908.
From diary number of they said SLP has been registered as diary number SLP diary number 244. Oh, which case?
24415. That is in respect of WPC number 21908. Yes.
24415 is?
What
is this? 2242?
2242 it's SLP diary number 6114 of 2024.
6114 of 2024. Oh, stop. Since the contemners have approached the Supreme Court against the order, violation of which has been alleged in the present contempt application, we are not inclined to, we are prima facie of the view that no deliberate disobedience of this court's order is made out. Stop. Next, learn senior counsel appearing on behalf of the petitioners has, however, submitted that filing of the said SLP before the Supreme Court belatedly, comma, that too when it is at the stage of that too when no notice has been issued and SLP number has been assigned, comma, this court should proceed in the contempt matter. This is what you are saying. First off, list this matter on 8 weeks under the same.
What's your place?
Which is the next case?
Oh, all the cases are
all
same.
the cases are same notes. Same batch case, similar
batch
orders
case.
have been passed common normally.
Common judgment.
Specialist fresh admission, item number 1, contempt 328 of 2011.
Oh,
Item 1, CONTC 328 of 2011.
This is a 13-year-old contempt matter alleging disobedience of an order of this court dated 23/6/2010, passed in WPC number 5165 of 2010. There is no representation on behalf of the petitioner. Stop. Next, the court is of the view that it appears that certain developments subsequent to because of certain developments subsequent to filing of the present contempt application, this application has lost its significance. So stop. Contempt proceeding, contempt petition is accordingly dismissed for non-prosecution. Yes. Yeah.
Item number 2.
Item number 2, my name is reflected in the contempt notes, S.J. Pradhan. Actually, the brief is of Mr. P.K. Patnaik. He is known. That brief is not with me.
Yes, I think it has become infructuous because lordships were pleased to initiate so much of contempt proceeding against the petitioner who had approached this honorable court in a surface proceeding. Because when he has already sold the properties, lordship wanted the crime branch to investigate in the matter. Crime branch investigated, submitted a report. Subsequently, I got the instruction on 5/7/2011 that a case under section 420, 424, 468, 474 has been initiated against those petitioners. Yes. He has sold it the property. That's why this contempt proceeding was initiated. And in the meantime, they've been in 2011 FIR was registered against them pursuant to lawsuit direction.
The court has some compromise in local order is there in rate application. No, that separate rate application was filed, and the what indicated in the 4825 rate petition. My lord, the rate application was filed and it was disposed of in 2014 probably. In Lok Adalat. What has happened that too, I don't know. In a Lok Adalat, division bench has passed the order. Justice.
No, here court was surprised that the bank had not lost their file.
Yes.
Court also suspected that what was the bank doing.
Oh.
So if they have complained, if they have done Lok Adalat also they have done that.
नहीं a read application टा 14/2014 ने dispose एटा आगरू हेची contempt टा आगरू
Exactly.
तो
This order.
माइल तो brief ता पकड़ा छे is no more. I'm not
No, but good
Well-
here, informing us what has happened. Answer for that.
Where are they? Where is the contender?
I don't know, Lords, whether the lordships are pleased to issue notice because nobody.
You are appearing for the contender.
No, my lord, my power.
He's saying he is appearing, the other counsel is passed.
Then I can understand, but your colleague was appearing for the contender.
Yes, my lord.
Okay.
But he'll have to be here.
He is no more, my lord. That
No.
I don't.
He
I,
is the
You
contender.
have to inform the party to be here.
I don't have the brief.
We'll give you the address.
It was the brief. It was his brief, and he was handling.
All right.
Brief is not with me.
Original order will can function the disposal and when contempt proceedings were initiated,
That's
special notice.
order dated 28/3/2011. I'm sorry, Lords.
No,
No, Lords, it's not that. It's a subsequent order.
that is previous order. This is 2011.
Yes.
28/3/2011.
11, yes, Lord.
So for a possession of the crime branch shall examine culpability of the bank officers. So far as possession of the mortgage property is concerned, so and so shall deposit a sum of rupees so and so. Property shall not be put to auction. Deposit shall remain after recovery of the entire loan dues of the bank from the amount attached. Then that thereafter they must have said after the entire loan dues are there, then the amount will be refunded to her. So shall we see what order has been passed or not necessary in the local petition?
Look at the.
When was the order? We can ask it to be listed along with the writ petition. WBC.
It is in 2014.
Matter on 1 week along with the records of
48 WBC 4825 of 2011.
WPC 48.
It's there. Don't have.
My lord, it will be with the.
It must be there, Lord.
He's saying it's there. Then it must be there. Let me see it here. Oh yeah, it is here. You can see it online also.
Is here.
Mhm.
Do you know what it is?
Soft copies there.
It on 9th April 2014 it is full.
9 April.
9th April 2014.
So in view of the order passed in WP server 29496, this writ petition was disposed of.
I would have it to get you.
294 subsequent writ petition.
That is 29496 of 2013. That is subsequent writ application.
Wonderful.
That's why this petition was disposed of. Principal only order dated 9/4/2014.
What was disposed of?
The WPC number mirrors 4825, out of which this mirrors content proceeding arises. That writ petition was disposed of with an observation that in view of the order passed in the WPC number mirrors
By which order?
order dated 9/4/2014.
Were there.
My name is there, man.
No, you have been heard on that day.
What signature correct?
No, you've been heard on that day. Mr. Patnaik was probably in the panel, so he must have been busy. He must have gone to address the court. On 2011.
2011.
Yes.
11, Mr. Patnaik was not there in the panel.
No, privately.
Then Mr. Pradhan has been doing the case.
Yes.
Again, you have handed over drafts, you have handed over checks.
No,
And where is that?
yes,
WPC 29496.
So get that.
Huh? Could you get that?
No, that has not been annexed. Only the record of this.
You'll also may call for that record so that it can be more convenient to take up this.
List this case on along with the records of WPC number 29496 of 2013. The reference of which finds place in the order dated 9/4/2014 passed in WPC 4825 of 2011, out of which the present contempt petition arises. So we will see. 2 weeks.
Item number 3.
This must have become rendered infructuous. Online applications and physical applications he was asking.
There is no representation on behalf of the petitioner. None counsel for the proposed contemners are present. Is present.
It has not been issued.
So the petitioner has alleged disobedience of an order dated 30/10/2012. Sorry. Beg your order.
10/12/2012.
10/12/2000.
What? Sorry, I opened the wrong. 2/12 of 2023. It is not notice not issued. I'm sorry, I'll give the right order.
2012, right? 2/12 of September. This contempt application
7/9.
pending for last more than a decade stands disposed of for want of prosecution. Yes.
Item number 4. Item 4.
What is that? Online and offline application. 1053.
Same. Same order.
Item 5.
10/12/2012. That is the violation of the order. देखिए सेटा लिखता हूँ. WPC 16031 of 2010.
Item number 5.
stamp reporting has also not been done. I don't know why. Yes. Sir, not great. Over the order, he must not have filed. Yeah, once.
Also, if you also look at the order, no content is made on page 7. In view of the above, the matter, learned counsel for the petitioner submit that the grievance as expressed in writ petition stands redressed. So,
Of the order of this court dated 25/11/2014, violation of which has been alleged in the present contempt application, it appears that no case of deliberate disobedience of this court's order is made out. This contempt proceeding stands dropped accordingly. Yes.
Item 6.
Requisites have not been filed.
But this matter is pending for last 12 years, nearly 12 years. For nearly 12 years. Stop. When the matter was taken up on 4/12/2012, there was no representation. Order dated 4/12/2012. The notice, notice was directed to be issued. But it appears that the to be issued. Post off. Post off. Today also there is no representation on behalf of the petitioner. This application is accordingly dismissed.
Item number 7.
Order will be complied with. It is treated with counsel for the counsel for the petitioner and contenders that this court's order, violation of which has been alleged in the present contempt application, has been complied with. Both of the contempt proceeding stands dropped accordingly.
Name, please. Your name. Sorry?
KK Mohanty.
KK Mahanti.
Mohanto.
Mohanto. KK Mohanto.
Item number 8.
Plan secretary.
No representation on behalf of the petitioner. The petitioner has alleged.
Well, also say its order has been complied with because he has been taken over to the regular establishment. I've got the order now. I filed the compliance affidavit B by 1.
It has been alleged over. Our attention has been drawn to compliance affidavit filed on behalf of the contemners, wherefrom it appears that the order of this court, violation of which has been alleged in the present contempt application, has been complied with. Contempt proceeding stands dropped accordingly.
Item number 9.
I please, yours. Way back on 6/7/2010, the order was passed, this judgment. This is of the year 2011. You'll also kindly come to page 7 of the contempt application where the order has been enclosed. 6/7/2010 in a WPC 13238 of 2008. Hard Swansu. Second part. All the 3 petitioners in pursuance to the advertisement issued by the Orissa Board, State Housing Board on 28/12/2002 for allotment of 6 number of duplex core houses submitted their application along with earnest money. A lottery was conducted on 7/5/2003 in the conference hall of the Orissa State Housing Board at Bhubaneswar, and 6 persons, including the present 3 petitioners, were selected for allotment of 6 number of core houses. The proceeding of the lottery conducted on 7/5/2023 Annexure 2 shows that all the 3 petitioners had been allotted with house number 1, 2, 3, respectively, in the state lottery. Thereafter, they were asked to deposit the required lease premium, and it is stated by the Land Council appearing for the petitioner that all the 3 petitioners have deposited the lease premium. The grievance of the petitioner in this writ application is that due to some encroachment over one of the said plot on which the core houses have been built, possession of the same had not been handed over to the petitioner. We find from annexure attached to the writ application that orders have been passed for removal of the encroachment, and help of police has also been sought for by the Annexure 6 to remove the encroachment. However, the encroachers have not been evicted as yet. From the map submitted by the Land Council for the petitioner in course of hearing of the writ application.
So what is the problem?
Now they have not given till date. You'll also see personal appearance was made. After the personal appearance was made, the suit was dismissed. The suit was filed by the encroachers. That has been dismissed long back. Then the direction was made for personal appearance. After the direction of personal appearance, they cancelled. They cancelled the allotment. So again, this court directed for personal appearance, and thereafter they recalled that order. Till date, they have not complied with. And if you also will look to the order sheet.
Mr. Rautare, that order is if the said core houses are free from encroachment.
Yes.
And there is no legal impediment in handing over possession of
Yes,
the same.
it is free now.
The same shall be done within the aforesaid stipulated period. What was that period?
The period that you also kindly see
So that if they have not done that and there is no impediment, then the contempt will be made out.
Yes, preferably within 3 months. You also look to that.
So all this which you are saying is subsequent.
No, we therefore dispose of the writ application, directing the opposite party to take immediate step for removal of the encroachment and hand over possession of the core houses in question to the petitioner and other 3 persons who have been selected in the lottery, subject to fulfillment of others, preferably within 3 months from the date of communication of this order. And if you also will look to the order. Thereafter also look to the order. They themselves.
If it is not possible to evict the encroaches within the aforesaid time, shall State Housing Board shall find out whether.
My entire case is, if you also look that there is no encroachment so far the core houses is concerned, that is from the map submitted from the map submitted by Land Council for the petitioner in course of hearing of the writ application, we also find that encroachment is in respect of core house number 6, and there is no encroachment so far as core house number 1, 2, 3 is concerned. And they themselves will also kindly look to the order dated 29/3/2023.
Yes. Yes, who will appear?
It's the housing board, we got notice as to who can appear.
Notice has been issued. If you also look to the order dated 24/4/2023, order number 16.
We will take up tomorrow. Tomorrow.
One more.
Regular, no?
One more item.
Same. Special.
Item 10 has been complied with. Item 10 will also get disposed of, order has been complied with.
Item 10.
Item 10.
10 complied.
Ma'am, there for the container number 2, the direction was to give until further order status that has been given, which were from 97, the juniors that they were given, and it has been complied with. Item 10.